wrong? What is the issue? We need to get to the heart of those issues. Okay, but we'll have opportunity for a discussion. Advocate Patwe, please, over to you and your colleagues.
Thank you, Honourable Chair. Honourable Chair, we have a presentation, so do we need to come and connect onto this laptop? So if we could just do the logistical swap.
I don't know if the cable doesn't the cable...
I don't know how far
the cable is usually... Is it shorter? Okay, no, I think the person must just come and sit here. Yeah. Okay.
Right. So, Chair, whilst we're doing that, perhaps I can just deal with a couple of issues that you've raised. And what I really appreciate, Chair, is your introductory comments that we need to be candid, because Parliament needs to properly understand and then assist law enforcement and other entities in trying to deal with these scourges. You asked a number of questions, and maybe I'll just deal with those quickly whilst we're connecting here. Firstly, your assumption is correct that when the legislation, the SIU Act, was created, the DSO was then in place, and the referrals going to the DSO made sense, because one of the aspects of the DSO was also dealing with serious economic offences and serious organised crime. So the economic offences part, the referral made sense for it to come to the NPA. Things have in fact since changed, and now we do have the IDAC, but as the Chair and Honourable Members are aware, the IDAC was made permanent only last year in August, but all of the referrals then, still in terms of the SIU Act, are referred to the NPA, which up until August last year does not have an investigative capacity. And so it's necessary, it's as of necessity, the matters have to go to the DPCI before the IDAC. And IDAC is a very small part of the work in any event. There's still a large number that goes to the DPCI. So you are actually correct that there's a need for an amendment to the legislation so that the referrals can be to the relevant investigative authority. Or we can talk about what language, but there is a requirement for an amendment, perhaps in the NACAC process, which is now the creation, which they are recommending the creation of this Office of Public Integrity, and there will be an opportunity to amend SIU legislation that this matter should certainly be addressed. And to deal with the issue that was raised about the Act itself, Section 41D, which says that when evidence points to the commission of an offence, does not establish the commission of an offence. And I would ask that, that the relevant slide of the SIU be amended to reflect that the criminal standard, as Advocate Motibi had explained, is whether it meets the criminal standard. The slide says it does meet the criminal standard. And I ask that that be amended because the criminal standard is very different from the civil standard. And so there's still investigation that needs to be done in order to meet the criminal standard so that we can make the decision to prosecute. So I think that's really important that is clarified, because you will see from our presentation as well. I don't know if we still have the slide in that talks to the pie diagram, the percentage of cases that actually we decline to prosecute, etc. It's there, which will give an indication of and some of the reasons for it. So that's on the first issue that you'd raised. With regard to IDAC now, that was your next question. Yes, there will be cases that can be referred to the IDAC. I do want to emphasize that the IDAC was made permanent last year, so capacitating the IDAC with the necessary skills and capacities has been one of the we've been focusing on that since August, and bringing the IDAC Act to speed. It already has a number of cases in its space, and so dealing with these matters relating to skills resources, which my colleague from the DPCI dealt with, is something that we are trying to get up to speed with that. But the one of the good news is that we've been, in the context of the presidential initiative, where Presidents is working with business in order to deal with the various challenges that the three work streams are: ESCOM, Transnet, logistics, and crime and corruption. A digital evidence unit has been set up in the IDAC. And it's still, the capacity is still small, but this is potentially something that is a game changer in terms of us having in-house capacity. Well, it's not within the NPA, but having access to capacity that will enable us to do digital analysis very, very quickly, because today evidence is on phones, laptops, etc., and that is one of the very rare, expensive skills that we need, and that has been delaying a lot of these cases. So this has been set up in the IDAC, and they've only just started with the first referrals of cases from the IDAC to the unit. So we're hoping that that will really be able to expedite cases. But I hasten to caution that this is a new, small unit, but we want to see how quickly and how it actually helps in moving the first cases through the system. So hopefully that will help. On the challenges and things, maybe I'll just deal with it later after the presentation, because there are some, you did also ask, maybe I'll just deal with your final question in terms of the provincial DPPs. You correct, Chair, that the provincial DPPs have the legal authority to make decisions to prosecute, not the National Director. In very specific cases in acts, the National Director has that decision-making authority, but it is essentially the provincial DPPs. An NDPP is a review mechanism that can review decisions of DPPs in various circumstances. And so we do have a specialized commercial crime unit at the national office, but also with presence in the regions. And Advocate Nkebe Kanyana is the is the special director in charge of that unit. So it comes up to national, where the coordination happens in her unit in terms of managing of the SIU cases at a national level. I'll come back to challenges later, but maybe we proceed with the presentation at this stage. I think I did, if we can just go to the first slide. Is this the first slide? Oh, no. Okay, so
can you just go to full view so that we can?
Yeah, that will be easier.
Slideshow.
I think, Chair, just that I had mentioned already, I think, just as a matter of introduction, and our colleagues have talked about the challenges with getting the statistics right. I think Advocate Mutibi correctly said that this mechanism through the presidency that's looking at how to, case management system is going to help us with this. I think for now I'll just leave it at that and just hand over to Matthew Sissoko, who will deal with the IDAC part of the presentation. We do have different presenters as well, so we can proceed on that basis. Thank you, Chair.
Thank you, Chair, and honorable members. From IDAC side, Chair, we've got 10 matters that we are under consideration by IDAC, which are referrals from SIU. These matters, we have 7 that are under investigation and 3 that are before court. Chair, I must preface my presentation by indicating that the matters that are under investigation, these matters are complex matters. And when we say complex in our environment, Chair, we mean that the nature of investigations takes longer to complete because of variety of issues. The kind of matters that we're dealing with, they straddle through different jurisdictions all over the world. So we have to contend with MLA applications and extradition applications, for instance. We also have a situation where we've got to do digital forensic investigations where we don't have in-house capacity, so we have to outsource that investigative part, and you find that there are terabytes of data that we have to contend with, that experts have to look at in terms of downloading the data, in terms of analyzing the data to enable us to conduct these investigations. The investigations themselves, even the statements taking and so forth, you'll find that it's hundreds of ARC liver files in one matter that we have to contend with. So that in itself takes long for us to complete these investigations. And coupled with the fact that since from the time that the ID before IDEC was proclaimed by the president, we worked with a limited capacity because we had to get capacity from other stakeholders like DPCI to be seconded to our environment to assist. And after IDEC came to operation, as the NDPP has indicated, only in August, we only then started recruiting our own investigators. But even that recruitment process, even though we went aggressive to recruit, it's a very difficult in the sense that attracting people with the necessary skills to be able to do the kind of work that we do, it's very difficult. So that on its own take time for us to be properly capacitated to move quicker with our investigations. I'll move to the matters that are under investigations. The first matter is the ESCOM Transnet meta contracts, ESCOM Transnet SAP meta contracts. I've indicated the issue of the complexity of investigations. In this matter, there has been a corporate alternative dispute resolution with the AFU, and we've been able to get 2.2 billion paid as punitive reparations. And in
sorry to interrupt. Maybe you can talk about the length. When you started investigations.
Yes. So this in this matter, we have 19 referrals from SIU. Now, you will note, Chair, that the case number there is 170 of 12/2017, which means the case was opened already in 2017. So some of these matters, you find that the cases were opened, they were either in the SAPS environment or DPCI environment. And at the time when IDEC or ID was established, then they were brought into our space. So in effect, it would have meant that the investigations would have been started in the IDEC environment at the time when the matter was either referred by SIU or either when we took over from the SAPS environment. And that would have been any time after 2019. So too, in the ESCOM ABB Impulse matter, the same situation obtains in relation to investigations. This is the matter where we're planning to re-enroll in the near future. There has already been a 2.5 billion corporate alternative resolution with ABB, which has already been paid to CARA. And then we've got Transnet Neotel contract. This matter, as I've indicated, also same kind of complex investigation. We have started with AFU on engagements with Liquid Telecoms with our new owners of Neotel for a possible ADRM to recover the funds. The next one is Cutting Edge. This matter is still also under investigation. There has been also a corporate alternative dispute resolution with SEP on this matter. 2.2 billion was recovered. And Transnet Nedbank loan swap. The same situation obtains in this matter. The investigation is ongoing. And then the SSA, SAT, and JM Aviation Swissport investigation. The same situation obtains in terms of investigation, and AFU still looking on the recovery side of it. And Alexco, the same situation obtains in terms of investigations, and AFU is also looking at the recovery. And these are matters that are before court. On this one, the ESCOM ABB gratification, the matter was enrolled on the 12th of July. The matter now has been postponed to the 8th of July 2025 for pre-trial. Now, just to speak on the issue that the chair has raised on why these matters take long after enrollment. Part of the difficulties we have in these matters, because of their complex nature, and we have in most these matters a number of accused persons and entities. In most of our matters, we have no less than 10 accused persons and entities. And you find that the accused persons will lodge interlocutory applications which we have to respond to, and that in itself lengthen the cases. The accused persons will from time to time change legal representations. That also delay matters moving forward. We do, from our side, when those things happen, do our own applications in terms of Section 342A of the Criminal Procedure Act to force the defense that we must go to trial. And sometimes we are successful, sometimes we're not successful, and that results in the delay in these matters. So these matters, as I've indicated on the APP gratification, is going back to court on the 8th of July for pre-trial. And the next one is the Kusile matter, which is going back to court on the 20th of July to 18th September for trial. And the AFU has already got a freezing order there of 1.4 billion. And then we've got a Dinel matter, which we recently enrolled, and it has been postponed to the 30th of July for a pre-trial date. And AFU is also looking there on recovery potential. I'll hand over to my colleague.
Yeah, he'll get the project. Good morning, Chair and members. I'll be speaking about the matters that are generally in the NPS. The NPS is the broader National Prosecuting Services. Whilst I head the the SCCU, which does the bulk of the matters that are referred by the SIU. Some of the matters will not result in the specialized units, but will be in the normal courts, the general stream. The previous speakers from the SIU and the DPCI spoke about the challenges in reconciling the numbers. As per your request to get to a point where there is a synergy with our numbers, we did meet as the three entities, and we tried to get to a point where we look at our numbers and see if they can reconcile. We looked at a period of 5 years. However, because of different reasons that some of my colleagues have mentioned, we did not get to that where we've got numbers that match. And there are a number of reasons for that. One of them, a simple reason, is that not all of the SIU referrals will end up with the DPCI. I think it was Advocate Mtibe who mentioned that the SAPS was also included when we did the MOU because of that realization. So some of the matters that are within the NPA that were referred by the SIU would not be in the DPCI books because of the complexity or rather the lack of complexity of those referrals. So the DPCI will only attend to matters that are of a complex nature, and there's a criteria of a certain amount. And so if it does not meet that, it will not be referred by us to the DPCI, but to the SAPS. Similarly, with the SCCU as well, whilst we do the bulk of them, some of the matters are done by general prosecutions in the regions. The NDPP has also alluded that the actual prosecution happens under the direction of the Directors of Public Prosecutions in the regions. We've tried different ways. So previously, the referrals were referred to the head office of the SCCU, where we would look at the referral and then decide and see which region it should go to. But because of the delays that happened with that process, we then moved to a process that is happening now, which is that when the referrals come in, they will be referred by the region, by the SCCU, by the SIU in the region to the relevant Directors of Public Prosecutions in the regions, so that it bypasses the delay that was caused by it. There are some referrals that will still come to the head office where perhaps it's not just one region that is involved, and then the head office will then route that referral. The other reason why the numbers do not match is that there is no central database at the moment, and they've all spoken about the current matter, that the current project that we are undertaking under the assistance of the Presidency and the Department of Monitoring and Evaluation, and hopefully this will be a matter in the past where we don't have where our numbers don't match. We'll have one version of the truth, as the SIU puts it. On the first slide here, I've put in the number of referrals that we have on the left-hand side for that period. It's just under 3,000 referrals that we were able to match. So we received the master copy from the SIU, and after deleting the duplications and things, that's the number we came to. And from there, we have in our books 1,695 matters that were then referred, that are under investigations in the different divisions. And 81 of these are matters that where a decision was taken already that there is a case, and then they are before court. 83 are matters where they were completed with a conviction and sentence. And then 229 is where we declined to prosecute. Some of the matters that are referred back would be, on merits, where I'm still on the first slide, please. So the nolly prosecute would be where we found that there isn't evidence to sustain a criminal prosecution, where prospects for successful prosecutions are low, and so we would then decline to prosecute. In other instances would be where we don't have the documentary evidence and the like to support the case, and so we would refer it. In some matters, it would be where we believe that the matter should not be dealt with criminally, but then there is merit for a disciplinary hearing, for instance, to be instituted, and some are, Okay, we can then move on. These are the matters that relate to the COVID-19 investigations. From these matters, we received a total of 304 that were referred to us, and these matters are dealt with under the auspices of the Fusion Center, where a number of, it's a multidisciplinary team where we've got other law enforcement agencies, including the SIU, the Financial Intelligence Center, and the others, where we then look at the cases and we fast track them to make sure that there aren't delays. At this stage, there are 81 convictions relating to the COVID-19 matters. It includes natural persons and companies. When we were here last time in November, we had 12 less. So there's been an increase from where we were previously. And just on the right-hand side, we've just put in a breakdown of sentences to show that at the bottom those are the fines, and we've put in the highest fine that was met, which was about 1 million, and that average fines are around 80,000. When we prosecute a company, that's all that can be put as a sentence, a fine. However, when we prosecute natural persons, then we could have where there is an option of a custodial sentence with an option of a fine, and then on top is there where we've had direct imprisonment. So those are sentences, 17 days sentences where there wasn't an option of a fine, but people were given direct imprisonment. And you can see there that the average sentences are around 8 years, and the high sentence that we've got was about 15 years for that. Thank you, Matthew. I've also put in a slide that deals with the National Lottery matters. As I explained also that some of the referrals would be dealt with by DPCI and some by the SAPS detectives. For the National Lotteries, we received 10 criminal referrals against NLC officials and some NPOs and some companies. And included there was cases that implicated senior employees or former employees of the NLC, including some board members. We in addition to those that are with the DPCI, there's then 16 NLC cases that are investigated by the SAPS, South African Police Services, the detective services. What I wanted to also mention there is that some of the matters that are currently seized with the SIU, the National Lottery matters, are yet to be referred. So some of the matters were referred to the Asset Forfeiture Unit, and there is orders in that regard for the assets. But in some of those matters, we don't have the criminal referral as yet. There are 26 dockets that relates to the National Lotteries matters, and because of the nature of how the offences were committed, they are being dealt with as one project. And maybe I should pause here to speak about and answer what was asked in terms of what is causing. What do we mean when we say it's complex and what's causing the delays? In this matter, the entities that were involved over, just have the numbers somewhere. It was quite a complicated scheme where we've had companies, about 22 individual people involved, and about over 18 different entities. The entities would be companies that were set up, would be trusts that were set up in order to create vehicles to steal the money, to defraud the NLC. And the number of bank accounts involved are also quite extensive. And because the money were layered up, moved from one entity to the other in order to disguise, it takes quite a bit of time to paint a picture where you're able to show who was the ultimate beneficiary of the funds that were stolen. And so it takes a bit of time to get the bank statements, get the contra bank statements, and then form a picture. And then we must then get a forensic firm that will then have an analysis of that to do the money flows and also to chart the different entities and people involved in this. It was agreed in both by the NPA and the DPCI that it would be premature to rush the matters and enroll some of the what people could see as low-lying fruit when we don't have the investigations complete. And so we are quite advanced with these investigations, and we're hoping that we would get to a point where we can enroll. However, some of the delays that happens, Chairperson, happens then after we've now enrolled, where we've now gotten to a point where we are able to show the racket that has been caused by this, and we get the National Director to issue a racketeering certificate. And when it goes to court, some of the interlocutory applications that my colleague spoke about would be challenging. We've now seen more and more people challenging the racketeering certificate that has been issued. And because, as I explained also, that there are many individuals involved, the interlocutory applications that are brought by the individual accused, and it delays the matter. Yeah, so I think that's all I want to say with the national lotteries, but I wanted to just demonstrate.
Sorry, can I just get clarity? And I'm just doing it so that we all on the same page as to what we are talking about here. So the interlocutory applications are the pre-trial objections, or what is that? Can you just explain what that is?
So, for instance, let's just take the racketeering application, for instance. So, the NDPP would have authorized that in this matter, the accused should be charged for racketeering. Now, you're not at a stage where the accused is pleading to the matter and you are interrogating the case itself, but it would be an application to challenge the certificate itself. Now, the prosecution of the matter in terms of us leading the evidence cannot start. So that is an application before the actual trial. So that is a form of an interlocutory application. Other applications would be where they, for instance, they challenge in one of the matters, for instance, the proclamation in this matter is challenged. So, for instance, I could say anything that has come as a result of that cannot proceed. So it's an application that is brought before the actual trial itself. Yes.
Okay, no, thanks. Okay, so I get that. So I just want to then ask about so the prosecutors have to provide a justification and evidence to the National Director of Public Prosecution to say in this particular case, the person or entities need to be charged with racketeering.
Yes.
Right? And the National Director will consider those presentations, and then let's say he or she decides that racketeering exists here. Then you enroll the matter in court and you charge the person with racketeering, or the entities, the people with racketeering, right? They then take on review the decision of the National Director to certify the crimes that have taken place as constituting the crime of racketeering. That's what you mean? That's what I mean, yes. Which then means the trial cannot start until that matter is settled. Let me ask you, so how long do these take? I mean, let's say ordinarily somebody, this is important for the public because it's some of the things that frustrate and make people really angry, because people get arrested, you think, okay, within a year, somebody is going to be in orange overalls or something like that. But you just never see them in court again, ever. Right? Okay, but let me not say ever, but they'll make a brief appearance 18 months later and then 2 years later and so on, right? So that is a frustration for the public. So I'm not being deaf. We really need to understand this issue.
Yes, so Chair, it's a matter of how long is the string, It differs from matter to matter. It differs from division to division. So it drags the matters. It can be a matter of months. It can even be a matter of years. And remember now, because you're not dealing with one accused, so one might bring a particular application. They might bring a particular application, and that might be decided on. And then another accused brings up another application. And I think perhaps because of where we come from as a country in terms of how people's trial rights were trampled, the bench is very accommodating, of all these, because they do not want to trample against people's rights to fair trial. But this is why at some point we also stand up as the NPA and say, we're going to bring that 342A application, which is where we're saying that there is undue delays that are being caused, because justice is a two-way street. It's not just about the accused's rights to defend themselves, but it's also about the state, as the people's lawyers, right to bring matters to court fairly. So we are also able to bring the 342A applications, and we do that. Sure.
If I may help as well, the Senzo Meiwa matter that's in court at the moment, there's been an application that's been brought to do with regard to something relating to his teeth. So that's an application that must be dealt with.
Sorry, which matter is this?
Senzo Meiwa, which is in court. It's not one that we're dealing with here, but it gives you and there's another one is a very famous case of where Billy Downer has been they challenged the authority of a prosecutor to prosecute the case. That matter's been going on for about 20 years. So there's a number of cases that we can give you examples of applications. And because we have so many layers in our system, the court system, it can go right up to the Constitutional Court. And so those processes take a long time. And where we have dealing with accused persons, particularly with means, then, these cases are delayed. Thank you, Chair.
Okay, I don't know. Now you kind of need to finish your presentation, but isn't there, and this is a layperson's question, why can't some of these matters by law and rules of court be left to the trial court until completion of the matter, and then the appeal court deals with all of the issues in the event that the initial court did not deal with them properly? This idea that all interlocutory applications can go all the way up to the court with their own court roles basically can provide room for gridlocking the system and never ever getting convictions, basically, if you've got the resources to drag the thing for 15 years. So what's preventing us here? Because I think in the US it kind of is like that. They're quite strict about what you can take to federal courts if it's a charge in their state system and so on, so that the trial court deals with as much of these as possible, and then later on upon completion you can deal with it. Or am I getting it wrong?
Chair, you're right. And I think there's a hand. Advocate Mzanyati can maybe let me give to him to say something quickly to address before I say it.
Thank you, Chair. Just on that point, and I think Chair is raising a very, very pertinent question. There is a shift now in the judiciary to do exactly what we are saying. Because there's been a tendency that if you bring an application for review, everything else must stop until the review is finalized. But recently, the Gauteng High Court said, no, we are going to continue with this matter while your review is underway. So at least that is a shift that is making us quite encouraged in the NPA, affirming exactly what the chairperson is saying.
Okay, let's complete the presentation and then have the discussion, because I do want us today to get to like 5-6 systemic problems that are just, yeah. Oh, sorry, Honorable Matiwan.
Thank you, Chairperson. I just wanted to follow up on this matter because I think it's a crucial matter which delays some of the court processes that the NPA is currently involved in. You asked a question which I think the NPA should be able to provide us with an answer, a decisive answer, on the number of cases that are affected by these applications. They can give us an average. Give us an average of how long do these applications delay the court processes, and also to give us because they might not be as innocent as they would want to portray themselves. Maybe there are defects in their certificates, or there are defects in the proclamations, hence the number of applications that are done by accused persons. So they should be able to give us the details of what is causing the matter. Because there's no point, as you're making this point, to take a matter to court, whereas there are defects where that judgment might be, you might give a judgment and then it will be overturned over something that could have been prevented in the first place. Because we're dealing with specialized units here. The SIU is a specialized unit, the NPA is a specialized unit, the Hawks are a specialized unit. So you in a way, you expect that the expertise and the skills to deal with complex matters are there, and that when something goes before court, they would have exhausted all the challenges that might arise. Because when you do scenario planning, when you do a scenario, you play out the scenario. How is this thing going to play out? So if you see from the onset that it's not going to move, they must be able to give us, from their part, what are the defects in their certificates, what are defects in the proclamations of the SIU, because there is a challenge.
Thank you. Can I simplify the matter this way, because I think it might be easier to give the committee an idea of the nature of the issues, right, or the extent of the issues. Out of 10, it will deal with racketeering and then general interlocutory matters, right? Out of 10, how many of these challenges to the racketeering certificate succeed, right? And we're talking averages here. That's the first, if you're able to do that. The second is just the interlocutory matters in general, right? Are they generally successful or not? And the answers to these are important because it gets to the heart of what Honorable Matiwana is asking, which is it a sort of a general defect in the system, or are there defects in the decisions in and of themselves such that they then become vulnerable to challenge? That's really what. So can we deal with that if you can? If you don't have the data now, you can deal with it when we get to questions, but it's important that we address this.
Yes, I don't have the numbers, so I can't punch in the computer and get the numbers that the member is asking. But what I can answer, Chairperson, is that we did an exercise, right? We did an exercise in the NPA where we took data from the courts, from all the courts in the country, where we calculated, we kept data of the reasons for postponements. So it was different categories, like, for instance, infrastructure reasons. So where cases could not proceed because of load shedding, no water in the building, and the recording machine not working. So infrastructure problems from justice, we have data on that. We then looked at reasons for postponements where it's at the state, where the prosecutor is not available, the prosecutor is sick, the prosecutor is not ready. And we looked at reasons for postponements where the presiding officer is not available, where it is at the defense instance, where the defense says, I want to make an application for further particulars, or further and better particulars, as they do. So they look at the charges and say, this and this is not clear to us. They ask for further particulars. So that's part of the other applications that come through. And so where the accused is sick, where the accused is still to find money to put the attorney in funds. So these are now the defense at the defense instance. So we looked at all the merit reasons there could be for asking for postponements over a period of time, and we looked and we looked at that, and the majority of the causes for postponements was not at the state's instance. There were, of course, cases where the docket was not in court. So that is the state's fault, where the investigations are not complete. But the instances where the matter was delayed, where the trial is ready and everything is ready and it could not proceed, most of them were infrastructure matters where the court cannot sit, there's no water, there's no load shedding. In the past year, it's been better, but this is now historic that we've done for a period of time. And so that answers the picture that was painted, and these are things that we take to the different fora that we meet with stakeholders. The PEEC, what does it stand for in DPP? Performance Enhancement Efficiency Committee, where we sit with the judiciary and the court managers, and we in the different divisions, and there's also a higher level where NDPP sits, and we looked at these things to say, the bulk of the causes for postponements is elsewhere. And that's why we say, sometimes we need the bench to be a little bit firmer, to say, no more. We've given the accused enough time for them to get an attorney. We're not going to entertain a change of attorneys, because that also causes a lot of problems. They change attorneys midway. And because, as I said, from where we come from, they are very accommodating, because you don't want to trample on the accused's rights, because tomorrow it's a cause for appeal, because then you didn't afford them enough time to get the attorney of their choice.
So I accept that, but you are the guys who introduced interlocutory applications. I didn't.
Yes.
I accept everything that you are saying. What you have not answered is the interlocutory issues. If you don't have the data to hand, so two things, and I'm glad you've mentioned this other report. If there's no legal issue, can you please provide that to the committee, a version of that, so that we understand? I would imagine it's a statistical.
It's a statistical.
It's a statistical report. Please provide that to the committee, because that will give us a sense. The second thing is, even if it's later, can we then just get a sense of, because we'll get a sense of the extent to which the interlocutory applications cause delays and that kind of thing. One. Secondly, whether there are defects, because earlier on we were talking about resource constraints in the case of the DPCI. So I'm not asking this question, and Honorable Matiwan, and we're not just asking them. There are real issues that we need to deal with as a committee, so we need to understand whether what is presented to the NDPP on the whole suffices to sustain the case, or it doesn't, in the sense that it falls apart under challenge. But I want us to finish the presentation, so can we just note
I'm right
note
at
the issues here?
Yeah. We can move, Matthew. So this is just a slide that I put in the previous session we had in November. I'd gone to details to explain the mechanism, the tracking mechanism that the colleagues have spoken about, and I also then spoke to this to just demonstrate the point. But I'm happy that the SIU has also alluded to this in their presentation, to say, like in this one, in this proclamation of rural development, there were 51 separate referrals that we received from one proclamation, one project code, and this related to 3 properties. And there were 17 suspects that were involved, and some juristic persons. It's one case docket, and it will be one court case. That's just to demonstrate the point that I spoke about earlier when I opened. The next one. This is a slide that just shows the different reasons for us declining to prosecute. We put it in a form of a pie chart, because it's just not possible to come and deal with each and every case. So we did it number based, to say the bulk, almost half of the decisions where we decline to prosecute, is where there are no prospects of successful prosecution, and this is the standard that we need to meet in order for us to take a matter to court. So if there are no prospects of successful prosecution, be it that we don't have witnesses that we can call, the evidence is not going to. It's not going to prove the case. We don't have documentary evidence that we can use. In many of these cases, we rely on documents that we can introduce to court to show the fraud. And the second part is where the evidence is there, but it's also insufficient. There's the bigger part, and then the other part is where the suspect has passed away, and so we cannot prosecute them. And then the next one is where there is some transgressions, however, we're not going to be able to prove criminal intent, and so we then recommend that disciplinary action should be taken. And then the small part is where we are then going to use some of the people as Section 204 witnesses to prove charges against others, and so in those instances would then not prosecute those people. So the last one is just, I just put one finalized case, a Battlefield case of 2020, where the accused was Matthew passed, a bookkeeper who defrauded the UIF of more than 11 million, and they were given a 135 jail term. Thank you, Chair. I'm going to hand over to Asset Forfeiture for the last segment of our presentation.
Thank you, Chairperson. I'll be brief. Some of the AFU cases were dealt with by our colleagues from IDEC. So if we move to the first slide, I just want to explain terminology quickly for the benefit of members who were not here previously. So where I refer to a restraint or preservation, that's just a freezing order. And then where we refer to confiscation or forfeiture, we refer to the last stage of making sure that it's monetization, basically. It's realization of the assets before the money is paid into the criminal asset recovery account, or it's paid back to the victim. Now, so right at the beginning, the Divisional Commissioner Mboto made the point around there's no central referral system. So in AFU, we get referrals from everyone in the room. We get referrals from IDEC, SCCU, broader DPPs in the provinces. We get referrals from SIU. We get referrals from DPPs in the provinces. So the spread of the matters here that we've dealt with in the slides would therefore reflect that spread around. We get matters from everywhere. We even get matters from the police. We'll get a docket from the police where there isn't a proclamation as yet. So I do want to make the point, therefore, that although our numbers and the SIU will never tally, that's not the challenge between us, SIU, and everyone else who refers. And on the first slide, if I could just pick on one matter of Tegeta Optimum Colliery Templar case, there we've got over, in the one case, we had over 20 defendants, which is the actual beneficiaries of the proceeds. We call them defendants. We will then have respondents, which is their companies or their wives or the directors, co-directors and partners. Then we also had over 100 creditors. So in the spreadsheet that we got from SIU in preparation for this meeting, there's 169 ESCOM referrals to AFU. So the point I'm trying to make here is, in one case, we've got over 130 parties in one case. So, yeah, I just wanted to clarify that point. But the rest of the ESCOM matters I've referred to, 8 of them, it's broadly state capture matters and Kusilo corruption. Second slide, in the first slide, IDEC referred to the 2.5 billion punitive reparation, which is nothing but a fine paid into the criminal asset recovery account. Then the rest of the ESCOM matters on the second slide is where we still have got freezing orders, which is restraint in Mohedin Pillay. It's still the ABB gratification matter. Hlakudi, as I said, is the Kusile corruption. We still have got 1.4 billion at freezing stage. The Transnet Newatel matter is the matter where it's a referral from SIU, but we all working together in this matter, including with IDEC. Hence, IDEC referred to the matter. The PRASA matters, next slide, were referred to by SIU. We've only dealt with the matter of Daniel Mutimkuli, where we've got a final order forfeited to the state of 5.8 million, and the rest of the PRASA matters are still under investigation. The next slide deals with National Lotteries Commission. I think the only point here that I can make is that we have got 4 matters. I've given an attachment, which is an annexure for 19 matters. And again here, I do want to raise the point that we had a lot of interlocutory applications, but our interlocutory applications are not similar to the prosecution one. Ours is The typical ones are exclude my interest. That would be a wife, a partner, a co-director that say, please exclude my interest from what you are going to forfeit to the state. Then we'll fight it out. We'll say, no, we've got enough evidence to show that you shouldn't even have benefited from this money. Then the biggest fight is around living and legal expenses from the proceeds that are under restraint. Every defendant, respondent will come back and say, I need 10 million to fight you, or I need 1 million per annum to feed my children. Then we go and fight it out because, one, this is obviously from proceeds. It's a scheme to get the money back. So, and also, I don't know why you'd need 10 million for legal expenses. So we go and fight it out. But in that fight, the curator also joined because the assets are with the curator, they're not with us.
Sorry, can I ask, how do the courts tend to rule?
We've got 98% success rate because we fight the cases ourselves. And in our country, I think we've made jurisprudence. The Constitutional Court, the SCA, all the courts have ruled we do need these draconian measures that come from the prevention of organized crime to fight corruption and crime like the rest of the world. So it's an international standard. So the precedent is set in our country. The courts rule in our favor. Okay, so from Transnet matters where we have got still a restraint freezing order of 1.6 billion to the rest of the other matters are broken down. It shows that, like for instance, the slide page that starts with South SA Express, it's a Northwest state capture matter. It was referred to us by SCCU, but I think it's an SIU referral. Then we've got a lot of municipality cases from provinces, and again, we still have got Busasa matters. In that list, we forgot to include Agrizi. We also have got his assets under restraint. We've got, from the Free State, 2 big restraints, the asbestos case that's currently running in the courts for 300 million, and then we've got a freezing order of 32 million, and then a 2 billion restraint almost for the Free State housing matter. Again, the other slides is a breakdown of municipality cases in provinces. There's a lot of cases from eThekwini. It's a mixture of, yes, it's a municipality case, but it's a state capture matter as well. Then we're moving along again from Vembe district, and between last year November and this year when we last appeared before Scopa, we got 2 matters from SIU in Mbombela. So we've got 2 matters in Mbombela district, a 24 million restraint order, it's a corruption matter, and 48 million. Then we've got other referrals which we call deeds registry matters. We've got the reference to the proclamation is 107 national from SIU. So we've gotten those 2 additional matters from Mbombela. Just on the last slide, which is the summary slide, asset forfeiture unit. I think the instructions were that we needed to show the difference or the improvement between when we were last here and date hereof. So I've shown the increases there. For the finalized matters, confiscation and forfeitures, we've got 2 since last year. Preservation of freezing orders, we've got 9, and the values have increased, and some of the referrals are still under investigation. So that's the end of the presentation, Chair.
Thank you, Chair. That's the presentation on the NPA. Just in conclusion, to address some of the issues raised, and it's a pity Honourable Matuane is not here, but he's raises very important issues. And the point is, are we as the state, in fact, the ones that are the problem, to put it quite bluntly? The racketeering authorizations, challenges to that is new. So we've only have 2 at the moment where the national directors, and we don't have a decision in those matters. So they are before the courts. And we will, in terms of the percentage of the interlocutory applications that we win as opposed to lose, we'll try, but I think it's going to be very complex to try to get those numbers, but we'll certainly do what we can to give the committee an understanding of what, whether the state is at fault in most of them, we're losing these cases or not. My understanding is that we are successful in the majority of them, but we'd like to have some, if we can give you some empirical evidence, which is going to be a bit tricky, but we'll see what we can do to give you that. I just want to, on the asset forfeiture point, the last points we're making, I think it's important for the committee to understand the importance of the work of asset forfeiture in the fight against corruption, and because it is all about money. And so we have a 2-pronged strategy to dealing with corruption. One is prosecutions and getting people, as you mentioned, in orange overalls, Chair, which for various reasons takes very, very long time. The other prong is asset recovery, to take away the funds. And in terms of the Act, Prevention of Organised Crime Act, you can have civil recovery or you can have criminal conviction-based recovery. And to explain so that people know, the conviction-based recoveries are dependent on a successful prosecution. So those recoveries will take longer because prosecutions take longer for various reasons that we can talk about. But the civil-based recovery is in terms of Chapter 6 of POCA, which is not dependent on a conviction. But there we can move quicker, and that is where the AFU has been doing exceptionally good work in terms of trying to recover monies in terms of Chapter 6 of POCA, utilizing a very innovative corporate alternate dispute resolution mechanism that we have put in place. And to explain, we have guidelines, and this is where, and I want to be clear about this because there's some misunderstanding about this mechanism. This is where only the corporates, the companies, can come forward and disclose their involvement in corruption, and we reach an agreement with regard to a settlement damages that they can pay back towards the state. But it does not include individuals. So directors and individual persons are still subject to prosecution, but the benefit of the resolution, one of them is that the corporate agrees to actually work with the investigators to provide evidence against individuals who will still be subject to prosecutions. We've had some very, very big settlements, and just to indicate to the committee that the illegal mining initiatives of government to tackle illegal mining, which was about 2.2 billion rands from asset recoveries that funded the entire government's response to illegal mining. I think that was about 18 months ago or thereabouts, where we had a whole of government approach where the Zamas were an issue. And so money from CARA, the Criminal Assets Recovery Account, where when the final order is obtained, the money that we freeze is then deposited into CARA. That was used to exclusively fund that project. So to just give the committee an understanding of the importance of the work of asset recovery in terms of supporting various initiatives. Just on some of the challenges, Chair, the issue of, I don't think we can underestimate what happened in terms of trying to weaken institutions during state capture, the Hawks being one of them. You raised this issue, Chair. General Libya, who's now retired, has often said, and the 50%, the fact that they are working at 50% capacity is simply unacceptable. The challenges with skills in those critical specialized areas is a huge problem for a number of these matters. including in the Big Prasa matter, which is a challenge that there's a lot of challenges in that investigation. Chair, I also want to bring to the attention of, and as General Makinyana said, we don't want these to come across as excuses, but the committee needs to understand the real challenges that we're facing. Witness protection is a real challenge. People coming forward to speak out against corruption, they put their lives at stake. So to get witnesses to come forward to testifying in a commission is very, like the Zondo Commission, is very different to testifying in a criminal case, where there are consequences to people's assets and their freedom. So putting your life and that of your family at risk is one of the challenges we're facing, where people are scared to come forward and testify. Dealing with the issue of salary, and as the General said, we're trying to, and the IDAC, we have experienced it now, where we recruit these specialized skills relating to particularly forensic skills. Because the NPA, and I think potentially the police, are actually guided by the public service salary scales, we cannot match salary scales that other entities like the SIU can actually give to the same skills, or SARS, the revenue service. Forget about going to the private sector. So we are finding that we are constantly bringing in people, training them, getting them to 2 years, 3 years, then they get much bigger opportunities in terms of bigger salaries. So I've raised this matter several times and said, unless we can find some way of getting the NPA and the police out of these, we will constantly be the recruitment ground for other entities within government and in the private sector. So it's very hard to keep up and to deal with these challenges. So that's a very, very important issue that we would need support on in terms of trying to address that. And I think I'm going to leave it at that for now, and we'll take questions. Thank you, Chair.
Thank you very much. Honorable Trolliver, I'm going to come to you. So I just want to just manage our program, because people haven't taken a body break, number one. Secondly, I want us to go through the issues sequentially, or at least according to a certain order. And these are the insights that I draw from the conversation so far. So where I'd like us to start is at the DPCI. When we come back, we need to start at the DPCI. If the vacancy rate is 50%, we need to understand how the decisions to prioritize are taken. We need to understand, one. Secondly, we need to understand what type of vacancies do you now have, right? Is it, the investigating officers? Is it forensic investigator? You guys know the issues. You need to give the committee a sense of what that is, because looking at these numbers and being unhappy that cases are not being dealt with, but the car has no wheels, doesn't help me to scream at the driver. Because a car has no wheels, it's never going to go anywhere. So let's start at the DPCI. When we come back, we need to understand it applies clearly, not just to SIU referrals, it applies to financial crimes and organized crime in general, clearly, because those are the numbers of the people that you have. So that is the first point, the first port of call. The second is we need to get to the NPA. So there are issues of resourcing, number one. Then there are issues, I believe, of the quality that you're able to produce and whether it then produces winnable cases or not. Because what the public sees is that the judge has kicked out some or other aspect of a case because it wasn't done properly. Repeat, the case is not ready. We need to come back. There's a postponement, and then the matter is taken off the roll or kicked off the roll because otherwise later on there might be a permanent stay of prosecution. It all looks like a mess to us as members of the public and as parliamentarians, and I'd like us to work through the issues systematically. The time is 11:14. I'll because of the volume of people and the limited facilities here. Honourable Trollips, I've noted you, just so you know, your hand. Are you happy that we come back and deal with this? Because I'm worried that we've been going 2.5 hours.
I have a doctor's appointment.
Okay, well, ask a question then, and then we'll take a break.
Chair, to you and the committee members, thanks very much. I unfortunately have to leave for a doctor's appointment. So, You know, there is a slogan that there's a war against corruption in our country. I looked at the SIU slogan, it says striking against corruption. You, Chair, said, why does it take so long and why do cases take so long? That's what the public want to know. We've heard the stories about Stalingrad tactics. I've also heard that the NPA also itself uses Stalingrad tactics. And I hear plausible sounding reasons. Some of them I heard 2 months ago when the NDPP was here about attracting skills, retaining skills, all of that. We hear them, they sound plausible. But I can't reconcile the plausibility of those stories with the claims in the Justice Committee this week of how successful we are. You yourself are saying we don't see NPA prosecutions. But let me go to my question. Let's use one case, the Omotoso case. We've been told here that there's a mechanism that's being developed to track cases. We hear about reviews, all that kind of thing. In the Omotoso case, the original prosecutors were removed from the case for incompetence. Was that taken under review? Was their removal taken under review? Because what confounds me is they've been reappointed to the Fort Hare case, which involves massive corruption, supply chain management infiltration, and assassinations. We know that the Omotoso case was botched by the second team, botched by 2 teams from the NPA. But the first team was reappointed. By whom? Was it taken under review? What were the consequences of that review? Because if our reviews are not giving us an insight into why we fail, we'll continue failing. Thanks, Chair.
All right, can we just deal with that? And I think your question is basically what was wrong with them and why are you now confident that they can prosecute basically a financial, yeah.
Thank you, Chair. I'll deal with that. On the Omotoso matter, we have made extensive public comment on this, extensive, in various fora. We were also called to Parliament, the Portfolio Committee, where we gave very, very detailed explanations. I can give those explanations again today because I think they are important, but we've made a lot of, we wanted the public to understand what happened. So these questions are being raised now, and I'm certainly going to deal with it again. So on the issue of the prosecutors that were changed originally, and I'll deal with the link to the Fort Hare matter as well. Those prosecutors, there were allegations at the outset that they had acted improperly and were influencing the witnesses in the Omotoso matter. Because of that, the team was indeed changed. The investigation into the conduct of those prosecutors at that time did not start immediately for the reason that in order to proceed against them, to investigate their conduct, we needed of necessity to have the evidence of the witnesses themselves, because the allegations were that they were being improperly influenced. So the Deputy National Director Advocate de Kock at the time, working with the DPP in the division, Mr. Madolo, decided that we will delay that investigations until the victims were already going through, testifying in this matter was not easy for them. So we will delay that start of that investigation until the witnesses had completed testimony. And so that investigation, in fact, commenced last year in August. So that team that was changed, and I'll deal with the link to the Fort Hare matter in a minute. And then the judge in that matter was very critical of the new team that actually prosecuted that matter. And the judge in the matter acquitted Omotoso, criticizing the conduct of the prosecutors relating to, for example, cross-examination, relating to certain evidence that was not led. So with regard to that aspect, which is the new team, immediately after that, I appointed a team of very experienced prosecutors from outside of the Eastern Cape to look into the transcript of that matter, to consider whether the conduct of the prosecutors, whether the judge is justified, does it require disciplinary, does it require training, what was the challenges. So I'm expecting that report to be on my table very, very soon. That's the second aspect. And then we decided that we needed to appeal this matter. And this is where I would urge colleagues and the country not to judge a matter before the appeal process. An example that I give is the New Lane matter. That matter, the NPA was scathingly criticized by the judge, who referred to a comedy of errors and lots of other comments. That decision was just last week overturned by the Supreme Court of Appeal, who in fact criticized the judge for the way the matter had been dealt with, and the prosecutors have been vindicated. So in the Omotozo matter, all I'm saying is let us allow the legal process to unfold. We have taken the matter on appeal. The judge in that matter has actually initiated a very novel process, which we have never dealt with before, where when a state appeals, we appeal only on points of law. So in this case, we required of the judge to clarify her factual findings. So quite unusually, the judge has now asked that we actually argue this matter in court, which has never been done before. So we are trying to figure out how it's only once the judge clarifies the factual findings that we will be able to properly outline the legal basis for our appeal. So that process is unfolding, and we will keep the committee informed about that process. The other point that Honorable Trollope raises is about the same prosecutor who was removed that was then involved in the Fort Hare matter. You're correct. And the minute that was brought to my attention, I spoke to Mr. Madolo and asked him exactly that question. How is it that the prosecutor, who was seriously criticized in one matter, is now involved in a very, very high-profile matter? He was then immediately removed from the team. So these are issues that the DPP and I've asked him for a report, and I'm not sure if we've got Advocate Mznyati sitting behind, whether we've got, the very question I ask is, how is it possible that a prosecutor criticized in one matter is then put in charge of a very, very high-profile matter? I do want to also say that, maybe I shouldn't say this. Okay, I'll leave it at that. But I hope that I've asked, and really, the word that Honorable Trollope used is that the prosecutors botched this matter. Now, I would urge that we wait until the appeal to then decide whether the prosecutors in fact botched the matter, like the New Lane matter, where the prosecutors were seriously criticized. And of course, we do lose cases. There's not a 100% conviction rate. That is the nature of our democracy. It's the nature of our justice system. It's the strength of our justice system. And then it's the issue of the Omotozo matter itself. I want to say that this particular case was a serious setback in our country's fight against sexual and gender-based violence. And with regard to addressing sexual and gender-based violence cases generally in the NPA, we have an extremely, extremely good record of convictions, of support to victims, and sadly this one, a very important case, has actually meant that all the good work is forgotten, and this one very important case is the one that judges whether the NPA is able to deal with these matters. So I don't know how much of detail you want me to go into with regard to the sexual and gender-based violence statistics, but I would just leave it at that. And if there's anything I haven't touched on, I'm happy to engage further. Thank you, Chair.
No, that's fine. Welcome to the world of professional football coaches. Because if you don't win the final, you're gonna get fired. So
I'm glad I'm not a football coach.
Yeah, so it's life. So it's 11:24. Can I ask that we come back at 22:12? Thanks. Okay, no. Welcome back, colleagues. So can I ask that we start with the DPCI's matters, and this is why it's important that we do that. If the investigative issues are a serious impediment, there is no point getting to the prosecution's bit without understanding what the problems are at that level. So my suggestion is that we deal with DPCI, we interrogate as many of the issues around the data that they've presented and the issues that arise. And then we move on to the NPA. So nobody's getting off the hook. But I do want us to interrogate the issues properly. One of the concerns I have, for instance, is the process of deciding which case becomes a priority. Because if your capacity is 50%, it follows that each detective probably has twice, each investigator probably has twice the cases that they should be handling, or whatever the measure may be. So that's a real material issue, for instance. So the process of getting there. I also, for instance, need to understand, when you say you're operating at 50 point something odd percent, what type of capacity is missing? So can you just take us through what you would consider to be critical to investigations, what is missing, the impact thereof, and so on, right? And for all of you, one of the questions I were to ask, for instance, and we can have the discussion, I mean, what's your budget allocation now? In an ideal world, how much should it be? Because it identifies a shortfall. Right. Otherwise, we're going to have a discussion that's all over the place and we end up nowhere. So, members, can I ask that we do that? So let's start with the DPCI, and then we deal with the NPA, because the referrals from the SIU are what they are. They are already there. So let's start at the investigations phase. Honorable Atkinson, sorry. Yes, no, but I do want to ask these foundational questions. So it might be secretaries that are missing, not investigators. For instance, I do want to know, when you say 49% vacancy rate, what are we talking here? How many of these are investigators? How many of these are forensic accountants? How many of these are whatever the case might be? So that we know what we're talking about. We don't talk in generalities.
Thank you, Honourable Chair and the Honourable Members. Maybe just to quickly break down the figures, Honourable Chair. The current figures that we have, that includes the support staff, not just the operational officials only. We are at 2688. And then the shortfall that we have is 2644. And the two figures, if you combine them, they give you the 5332. Now, in this financial year, that is 25-26, this financial year, the police management and ourselves have agreed that we are going to prioritize 500 posts. These 500 posts, we are going to divide them into two. 300 would be the posts that we advertise internally. That will be for the posts, the kind of posts that we can find, that we can source internally within the police. That will be the investigators mostly. But then the 200, we have reserved it for external advertisement. Now, the external advertisement will talk to those posts that we do not have the capacity internally, like your forensic accountants, We are also in the process of capacitating the cyber crime, the cyber security environment, and we think that if we can enhance our capacity within the cyber crime space, and we enhance the forensic accountants, because most, maybe when I explained earlier, Chairperson, I mentioned that one of the things that delays our investigation is the outsourcing towards the forensic accounting, but also my colleagues from the SIU mentioned the digital world, because a lot of our things are now, or crime now is in the cyber crime space. So we, with the 200, will focus on the skills that we don't have internally, your forensic and the colleagues in the IT environment. And then the question that the chairperson asked, where our critical shortage is. Our problem is not necessarily within our support space, because even if there is, we can survive with those. Through natural attrition and some of our colleagues poaching, in that we tend to fish in the same pond, and we take from each other. But the critical aspect for us is on the operational environments. The investigators, particularly those with a specific skill that is required. When I joined the DPCI chairperson, I was coming from a murder and robbery environment. I didn't think that investigating murder could be shorter and quicker than the cases that I find in the serious commercial crime space, where you walk into one place and you find the whole office is just full of one docket with the different files there. So the complexity is so vast that when we lose those, even if we do get replacement, it takes us time to bring him to a level where we can be comfortable that he can build a case that the NPA will find suitable to take to court. But those are the figures that we have, Chairperson. Thank you so much.
Okay, so let me ask thank you for that for that answer. Let me ask the question in this way. My impression is that the days of the police or the Hawks rocking up with bakkies and removing big files are gone. I haven't printed more than 50 pages in the last 6 months. Right, okay? How are you doing on your skills level of your current crop of investigators versus that technology environment? Have you made an assessment of that reality? Because we, as you said, we're dealing with the digital environment and so on. And yeah. So how are you doing on that? The skills, have you made an assessment of the skills level of your investigators of commercial crimes in general?
Thank you, Chairperson. Indeed, we have. But what we realized, Honorable Chairperson, was that it might take us longer to try and convert your traditional investigator into a competent person in the cyberspace. Hence, we created a support environment that supports him irrespective of his skill level. Hence, the cyber capacity that I spoke of, the forensic accounting that I spoke of, are people that support that not very skilled individual, but they themselves are not the one that are investigating, but they create a capacity for him. So meaning that if he has your device, he might not know how to access those items there. But when we send him to to your office to pick those up, we'll send him with an expert who will make sure that it's handled correctly, the evidence in a correct way, and then he analyzes it and then gives him a report that he will then file to take to the NPA. Thank you, sir.
No, thanks. I understand how you're mitigating the issue. But what I need to get as a general impression is whether, maybe given the age and the training that your investigators have received, whether they are up to speed. Forget the vacancies, because we're still coming to that. Are these people who are au fait with the technological environment in which we live? Because even calling on the capacity to assist you, you need to understand the implication of what you're looking at. And I see even here in committee where people don't understand the implication of the very thing that they are looking at themselves. So that's why I'm asking the question, because we can get to the fundamental issue. And it's not a criticism. Not a criticism. The teaching profession is dealing with the same. And I can go on. So I just want to get an understanding. Do people need training, or you feel that you actually just need to get as many new people as you can into the system who are able to work with these instruments?
Thanks again, Honorable Chair. There's room for improvement. Definitely, we could do better with the training. But what we have tried to try and mitigate in another aspect, Honorable Chairperson, is that the new ones that we are recruiting, we have agreed with the management of the SAPS that if they give us a new recruit that has just been released from college, they will give us those that have specific qualifications, whether it's law, whether it is IT, and whether it's accounting, because those are the critical ones that we need. To answer directly the question of how's our skill set if you were to remove the support environment that we have, there will be room for improvement that will be needed in that space. And although we do have a few individuals who will be equal to that challenge, but you might not have the two in one place, residing in one space. The capacity to investigate and the skill set, whether it's the forensic accounting or whether it is the cybercrime investigation. So hence I've then said to the Honorable Chair, it is that, therefore that is why we are prioritizing the capacitation of those environments. There is hope that with the infusion of the new people that are joining the DPCI, as I've just said, that we've already agreed with our HR head office that those that will be sent to our space will be those that possess that specific skill that we're just going to train them to investigate. Thank you, Chair.
Now, this is my last question. Then I'm going to hand over to the members, and I will give my impression, and you tell me if I am incorrect. I think that someone with a BCom law would be extremely useful to your capacity, because they're not just looking at the transaction as an accounting entry. They're also able to look at it relative to what legislation allows or does not allow. They can look at reporting, they can look at statement of assets and so on in an income statement and see that something doesn't make sense here, because this is not supposed to be classified here, it's supposed to be classified over there, right? A direct question. Are you able? Well, two questions. One, in your current ranks of investigators, what is the proportion of people with that level of skill and education? And the degree is one thing. Then you need to go and work somewhere, either for a law firm or for Deloitte or whatever the case is. So one, how are you doing on that capacity? Because I think that is that is important. The second thing is, in terms of your current salary resourcing, are you able to hire those people? Let's say if somebody with a BCom law and honors 5 to 7 years working experience, let's say in a particular environment, are you able to hire those people?
Thank you, Chair. We, as I explained earlier, we are in the process of initiating this forensic accounting. So we do have chartered accountants. I think we've got 2. And then those that are a level lower than chartered accountants, just that I didn't get the records with me, but in that space, I think we've got 16. And as you might see, Honorable Chair, the numbers are quite low. Because if I'm talking, I think as of now, we are around 16 in that space of forensic accountants. So the number is low. And are we able to attract the required numbers? When we advertise the post, not a lot applies, as my colleague here has said from the NPA. And not only that, even those that we have, sometimes they leave within a year or 2 after being there. But I don't think it's a hopeless situation, though, because as I speak to you now, we do have 2 chartered accountants in the office, and they've been with us now for, I think, 3 or 4 years. 3 or 4 years. So they've been with us, and they came with a reasonable experience. And I agree with you 100%, Chairperson, that a person with a qualification such as the one that you've mentioned adds value, and will see things different than an ordinary investigator that would be there. Hence, we agreed that going forward, we will only bring in capacity. It might not always come with the experience of workplace experience or exposure to the workplace, but at least we will bring in someone with the qualifications on which to polish would be easier. To mitigate this, Chairperson, we have entered into an agreement with the private sector so that these people that we have with at least qualification but not have workplace experience, they work together so that they share experiences so that they can wrap off the skill set to these new ones. And we do have a program that is run from the presidency, this joint initiative, where in this financial year, we have put in place between ourselves as the police and the private sector, 75 million each, which gives us 150 million. From this 150 million, we are going to use it to fast track these investigations that are moving very slowly. So the assistance will not be only from my 16 forensic accountants that I spoke of, but we've got from the business. They've identified forensic companies that will assist us. So I'm trying to say this, Chairperson, that there are initiatives in place that will at least address your concern about the pace that we are moving at. Thank you.
No, thank you. And please don't view this as an attack. My concerns are not addressed, and it's not your fault. I'm not blaming you. So, for instance, when you say you've got 2 CAs, right, I need to get a sense of 2 CAs where? In the entire Jesus. I'm sorry to say, it can't be, because also CAs are different. Others specialize in auditing, others specialize in cost accounting, others specialize in management, finance, and so on, right? 2, I am sorry, is not gonna cut it. And I'm raising this because it then goes to the heart of whether we're able to complete the investigations in any reasonable amount of time. It genuinely does. I am not blaming you, right? But we need to call a spade here. What is clear, because what my feeling, and you will correct me if I'm wrong, is that the training that most of your investigators have is for pickpockets and murderers. Those investigators are expected to investigate financial crimes. And basically we're sending people to a gunfight carrying a knife. That's the picture that emerges for me. And we are going to come to the prosecutors, but the reason I am interrogating this at this stage is that if there is very little prospect of a complete docket getting to a prosecutor, we are wasting time as a country, basically. So that's the sense I wanted to get. And please, again, I am not attacking you. 2 CAs is not. And let me just say, and this is a comment, this is a fundamental problem with doing away with the DSO. And this is what has occurred, because the DSO could hire people from auditing firms, from banks and this kind of thing. That capacity was taken away by law. It has never been restored, either in terms of the financial support that is required, because then you can't hire the people. Right? It's a comment that I'm making, but it's clear to me that unless we are able to hire people with the kind of qualifications so that you are sufficiently capacitated. Because my next question is going to be, of your top management structure in the DPCI, does anybody have accounting as a qualification? I'm asking seriously, do you know?
Yes, we do. We have 2 senior managers. This is a chartered accountants that I spoke to. They are both in senior management.
So, but you see, so in Gauteng, for instance, you probably need 30, 40.
Indeed.
Given the size of the economy, the number of companies and so on, right? Just in Gauteng alone. So if we have 2 nationally, we have a problem. Clearly, right? And we will wait forever for people to get arrested, and they never do. Because of, anyway, so let me give the members an opportunity. But anyway, I felt that was important to establish, because I think we all playing it. Let me go with in sequence, right? So that we'll start here this time. Honorable Mende, Honorable Matiwa, and I don't know if you want a second bite, and Honorable Esak. So let's do that, and then we'll take in 3s.
Thank you very much, Chair. Good morning once more to everyone. Ntombuvi Yomente, member of SCOPA, deployed by the EFF. No, the first question is also in relation to what the Chair was seeking to get a clarification on, especially in terms of capacity. I'm going to point you to 2 reports you have given to SCOPA. 2023 report, it was obviously General Lebeya. 2024 report, now your report today. Now, in the 2024 report, we've got, in terms of the accounting of cases, we've got 18 cases where the National Prosecuting Authority declined to prosecute. And then this one, you have 15, which I think cumulatively, they come from the previous report, some of them. And for me, that's very problematic for the NPA to be telling a specialized unit that there's no grounds to prosecute here. So this talks to exactly what the chairperson was pointing out. That what kind of a capacity refers a case that they are not comfortable and satisfied with, that it can lead to successful prosecution. But yet, yes, it's sent to NPA for decision, even though it doesn't tick all the boxes. With the hope that for some reason it will be conveyor belted to the court roll, and then a judge or a magistrate says, but this is a nonsensical case you brought here. Then it comes back to prosecutors that they fail. Now, at what point do we send such cases? I know you will justify in terms of each case, what were the reasons of there are no grounds to prosecute? There will not be any successful prosecution in each of those cases. The question is, at what point do we send a docket to NPA for prosecution where it does not tick all the boxes? Who monitors such a process and okays it to go through? I'll also tell you why I am worried and fixated on this particular item, is that in South Africa, since the dawn of democracy, we are now on austerity measures. You know, the biggest gap in South Africa is corruption. Money flows through corruption. And you know the worst pain? No one gets arrested. So our hope is that once the SIU says, gets a proclamation, we then have a hope, and then they come here to say, we see something, we can hold on to something here. Then they refer a docket to you, and you send it to NPA. Before we hammer the NPA, it comes back to say there are no grounds. So what is the process that you undertake once the NPA says there's no grounds? Yet the SIU is saying, take this case, there's something here. Money has vanished. We can point to people who have stolen it. We can point to items that have been purchased with it. We can point to accounts that indicate a crime where money was flowing from this account to the next account. So do your part. The second one, Chair, is the cases that are under investigation. Yes, I get the capacity in terms of investigators. You know, Chair, over and above the DPCI not having enough capacity in terms of general investigators, the progression in the SAPS is rather also unfortunate. So that is why the DPCI will not have an extraordinary eye to also poach from the detectives at a police level, police station level in terms of commercial crimes. Because I think it's the issue of regulations, where everyone is at a lowest rank, not easily picked up, not easily shine, to a point where such units can start taking very progressive detectives from police station level to push new recruits in so that they can go and close the space. However, we have universities which I believe produce the prerequisite skills now. And the question becomes, what's your relationship with universities in order for you to capture those that have that skill from the level of universities to such an extent of maybe some of the colleges that may produce some of the required skills on your unit. Then the last one will be, there's this one case which is It was in your last report, and it's still in your report now. It was finalized, but the person was found not guilty. I'm interested to know what was this case and why was the person not found guilty. It doesn't have amounts attached to it, but the fact that it went through from SIU to yourself to NPA, went in front of the magistrate or maybe a judge, but the person was found not guilty. It's related to what my colleague was asking. The judge will then say the NPA botched the case, but it went all the way through, gone there as a certified case that there's something to answer. Yet a person walked, or people walked. Well, I would like to know what was that case about. Thank you.
Thank you, Slad. Andizubamte bulise kuwe, bulise ku advocates, SIU, national head, NPA, no general or lieutenant generals, the Hawks. And myself mani thuba lobulise eqaleni. No mhlekazi wami into endifuna uyiqonda mna on the operational challenges that are linked to the high vacancy rate within the Hawks. If we can be provided with the statistics on the cases per investigator, the success rate, and other operational things that are affecting the work of the Hawks, I think that would be of assistance to us. Because we came to look at the briefing was not on operational issues, but we find that now that the issues might be operational that are affecting the work of the Hawks. Thank you.
Thanks, Honorable Matwan. In fact, added to that is just the length of time each docket takes to complete. Linked to it. So thanks for that question. It's very pertinent. Honorable Isaac.
Thank you for the opportunity, Chair. Good morning, colleagues. Chair, I'm going to be very brief, quick one. I just, as a matter of concern, and I need to understand this correctly, in the earlier presentation this morning, I got the impression that there seems to be somewhat of an obscured line of instruction between the NPA and the DPCI. And I just wanted to get clarity in terms of why is there this obscurity in terms of instruction, if you can comprehend where I'm coming from. Okay, I'm sure you would. And then, of course, I think it was just raised now, again, looking at the notes, there's some 96 dockets, obviously, that seem to be pending decision at the NPA that are outstanding. Now, I just wanted to understand again, the timeline around that. I realize your explanations earlier, etc., but somewhere along the line, Chair, through you, I would, ask that we try and bring some finality and some conclusion to these issues instead of sitting back here in 6 months' time and say, well, we're down to 86 from 96. So I just wanted to get some clarity on that one. Thanks for the opportunity.
Thank you very much. I think from my side, there was a question that I had asked. What is the guideline for choosing which case is going to get prioritized? Because I had asked that. Thanks. Can we then deal with the questions from the honourable members, and then we'll take more members afterwards.
Thank you, Honourable Chair and members. Maybe let me start with the last one about the figures, because I can see that it could mislead. The difficult aspect about cases that we take for decision to the NPA is that three things three types of actions sometimes come out of it. The first one is that the case docket might come back with further investigation that they have identified as requiring additional investigation. The second thing is that they might decide to prosecute on it. And obviously the third one is that they might decline not to prosecute. But the problem with the figures is that it's a living type of number that constantly change, because that 96 would have been as it was when we compiled the presentation. It might have been that 20 of those have already come back yesterday or today, and 20 others or 10 others have gone back. So it is difficult if we come back and we say 86 is now the figure. It might not necessarily mean it's that 86 from that original 96, because that numbers that we take for decision is constantly a changing numbers. I send to her, she brings back, we bring new ones. So that figure is a bit difficult to follow. But then my colleague will answer the question from the honorable members. Thank you.
Sorry, can I ask before you move on? There still has to be a sense of progress, right?
Yes.
In the net result. So I understand that what had been referred back might then get sent up again and is prosecutable. But it's got to be possible to track that. Otherwise, then it means we will never know, right? And if you're not currently tracking that, basically compiling the information in that way, I'd like you to, for next time, please do that, right? Because it just assists us to know whether there has been progress or not, because also new matters get enrolled and then they get, you know what I mean? Then it means sitting here, we actually just don't know whether those specific matters that had been referred were subsequently, they met the standard for prosecution later on. The question I'd also like to ask the NPA for when we get to you, because it applies to we've asked it in the case of the TPCI, and that is even the prosecutors themselves, given the type, because we're talking commercial crimes here, because there is a possibility that even the person who has to make a decision about whether a case is prosecutable or not, in and of themselves also don't know. So you've got a double whammy where both people are at sea about the case they're investigating and making prosecutorial decisions on. So just we need to deal with that when we get to your point. Please proceed.
Thank you, Chair. Chair, I would like to maybe start with the very first question from Honorable Mente, where she wanted to understand why we have such a number of declined cases. At what stage do we submit the cases? Who check if these cases are ready to go to NPA? Maybe in responding to this question, Chair, I would like to indicate the PGI, that's what we call prosecution guided investigation. So the prosecutors in our matters, Chair, they don't get involved when only the case is finalized, the investigation. They get involved from the beginning of the investigation, and the prosecutors would also, as much as the police do the investigation plan, the prosecutors also contribute to what should be done in that particular investigation. And when both of us, we are now satisfied that the investigation is complete, every aspect that needed to be followed up has been followed up, then the decision comes. So it is not matters that we decide as police to say, no, this one, there's no merit. It is already in the table of the prosecutors, and the prosecutors will then make a decision to say what we have collected does not take us further to court. Hence, those cases are then declined. we are not submitting the case on the completion. We moved away. That was the situation before, where the police would investigate and finalize and then send to the processor for decision. But now they get involved from the beginning of the case. At the end of the day, it is the NPA who should make that call to say this matter cannot be taken further to court. Nobody can be charged. So that's how now we have that numbers. I think I've tried to cover all the aspects which the honorable member have asked on that. Now, the second issue was also I think there was a question whether in the recruitment, I think there's a mention of the detectives. I just want to indicate that the DPCI still appoint members, investigators from the detectives. However, the recruitment strategy have a little bit changed to cover what the chair have been talking about and what the honorable member have talked about. There are members who are now appointed directly from outside, externally so, to the DPCI because of the very qualifications that we talked about that are relevant to our cases of investigation. However, as my divisional commissioner indicated and the NDPP indicated, we are not able to keep those people for a longer period because of the other competing agencies that are able to pay more than what the government is paying. But the detectives still move from the detectives to the DPCI. And even on the training that we have now in the commercial crime space, there is a review of the modules. There are professors from certain universities that are also assisting us to upgrade our training in the commercial crime space. The other point that was raised by the honorable member there, he would want to know the statistics of the number of cases per IO and the successful rate. And the rate necessarily because of the complexity and the big matters we're dealing with, not to put one investigator per case. That's another what you call process that we are doing. Now, we end up now some of the matters investigating them as teams. But that's where now, again, we got caught in the sense that the prioritization of the cases at times needs a team to prioritize certain matters over certain matters. So, as much as we can bring the number of the cases per investigator chair, but it might not. I felt it's important to mention that at times these investigators get to be appointed to certain teams. And because of the shortage of the personnel, these teams move from one priority to the other. Chair wanted to know how are we prioritizing the cases, what are we looking at? There are a number of issues, Chair. One of them may be the cases already enrolled in court. I think in the previous, before lunch, there was an indication that at times there are applications for further particulars from the state, further particulars which were not necessarily covered in the investigation of the case. So as much as those dockets are at court, Chair, but we still have members that are running around trying to cover whatever that is needed in court in that particular matter. So now we end up now having one team, having maybe 3 or 4 priorities, which they have now to move from one priority to the other. That's where this issue of the resources is catching up with us, Chair. But I am sure these figures per investigators, we can provide them, Chair, if we are just given time to prepare that by the committee. We can present that, but I want to indicate that at times the very same members who have those individual cases form part of different teams. I'm sure we'll be able to explain further on that.
Sorry, can I please interrupt you if you don't mind? So look, I don't think you've answered either me or Honorable Matiwane satisfactorily. So what I need to know, and I'll tell you what my simple mind is thinking, right? Maybe you prioritize cases where the sums of money involved are too big. I'm thinking maybe that's maybe that's part of your consideration. Or maybe you're considering whether it is high profile or not. Not all corruption gets reported and publicly in a publication, but you might nonetheless have an investigation going which none of us know about. What I'm trying to understand is what considerations go into the prioritization. I understand the need to support the prosecutors because a matter is pending at court and the postponements cannot be indefinite. I get that. But I'm just saying, given your resource constraints, how do you choose which case proceeds at 100 k's per hour, which proceeds at 40 k's per hour? It's a real question. I mean, we just want to understand of the kind of choices you have to make.
Thank you, Chair. Chair, as we are now having the NPCOC, which is the National Priority Crime Operation Committee, this committee moved from, we had ACTT before, and then in that ACTT we had a criteria, Chair, that we were following, which now moved to the ACTT, where we look into a number of issues, the public interest, or the value, as the Chair is saying, and also the impact of those cases to the government and the citizens. There are a number of issues that we are looking at, Chair, and those, at the end of the day, once that case passes that criteria, then it becomes a priority matter. We had a list of priority matters that we were keeping them as a CTT. We have moved them now to the NPCOC, which is also all of the agencies that are here are participating in it. Thank you, Chair.
Thank you. Can I just give my impression? I think it depends on the detective or the investigators which case is moving by way of witness cooperation and availability of information, because you have not answered the question. I think what you are telling me is that there hasn't been a specific macro level guideline on how you prioritize cases at your level. There is now going to be, because that's all I wanted to know. Is it the amount of money? Is it, what is the issue? Advocate Badu?
I'm just going to emphasize what General Makinyane just said, that when the ACTT was in place, there was a very specific initiative to address exactly what you're saying. How do we prioritize? How do we decide which cases will be dealt with in what order? And it's a that document took months to get together, and it deals with a whole lot of criteria, whether it's the value, whether it's the profile of the person concerned, the impact that it could make, and then there's even weightings that are attached to it in terms of the weightings and in order to determine the prioritization. So that is what in fact guides the prioritization. So it's a very clear, detailed document that assists the SAPs in prioritizing investigations then that the other entities get involved in. So I just wanted you to leave you with that, and not to think that there's no very structured approach to it, because it is there. Hopefully it's being applied in that way, but there's definitely a lot of thought that went into this very issue, and there is a guideline to address this very issue.
All right. No, thank you. Honorable Member.
No, thank you, Chair. No, Advocate Badoy is mentioning the work of the ACTT. I thought she was going to continue explaining to us what happened to that ACTT, which used to come and give us monthly reports. But in addition to the question which is being explained, I'm going to make an example now. You said there's about 500 new recruits. You are going to look for 300 internal, 200 external. I'm already seeing a danger because, yes, you're going to do 300 internal, and that internal is going to upgrade all your entry level that are dealing with the collection of data, compiling of documentation, looking for whatever information that's not very serious. And you're going to take 300 people from that space to the top. You're going to leave 300 spaces open, which is going to take another process to fill it up. That talks to the systems that are not in sync. You don't know how to fill, where you're going to be filling that gap from. It's not coming from college. Hence, I was asking, is there a relationship you have with universities or institutions that are producing the skill you are looking for, so that you can quickly fill in that 300 you're going to lose? The 200 that's going external is fine. It's people that are looking for jobs, good thing. We're welcoming it. But the 300 internally is going to create much more chaos for your prioritization, because you're not going to have the person who's collecting information from the ground. And the last one was on what you were responding in terms of the cases how you are prioritizing. I want to give you an example. You have Department of Health that the case is above 1 billion in terms of the amount you are investigating. It's 89 cases. We don't know how much each case has, but cumulatively it's above 1 billion. You have cases in court. It's 50 cases, and then 49 is still under investigation. You know what is happening now? Clinics, hospitals, and everyone, corruption is taking place because these 89 people are not being prosecuted. We have heard about someone being arrested somewhere, briefly appeared, then was gone. Then the others are continuing. By next year, this time when you get here, we may be finding 2 billion in the space of health. But more than that, people are dead because it looks like nothing is happening. So we need to understand your prioritization so that we are able to even say, Chair, in a social cluster where a basic service delivery is affected, we can't leave this space open. It has to be prioritized. I'm just making an example with health. If you don't find a certain machine in a clinic where a tenderpreneur was supposed to have procured an equipment and procured a substandard, now an operation can't take place in a theater because the equipment is not up to standard, that person dies. And then when the case gets to DPCI, it's not prioritized because of whatever. That we don't know. That's exactly what the Chair and Honorable Matuana are asking. How are we getting to a point of saying we look at the importance of the case to make sure we nip every corrupt element in the bud and not open a room for it? Thank you, Chair.
Thank you, Honorable Chair. It is indeed true that in the 300, there is a possibility that we would promote people who are inside the system. That is correct. There was a question, Chair, that was asked about the universities, the relationship that we have with the university. We do have a relationship with the universities. The team that I spoke of earlier from our forensic accounting goes and do some career expo or similar thing at universities to attract the young interested, the student that might be interested. the honorable member spoke of how do we prioritize. I'm not sure that the ACTT approach that my colleague tried to explain was understood. What happens is that in the NPCOC, which took over from the ACTT, because the ACTT was only focused on corruption, now the NPCOC has broadened the scope. It now includes organized crime, it includes corruption, it includes serious commercial crime, the NPCOC. In that committee, SIU sits there, the NPA sits there, ourselves, and the SAPS sit there. We then look at the cases, and collectively, we decided we will prioritize the following. It is a monthly process that we report to, and then the criteria is similar to what was at the ACTT, where we were looking at public interest, where we were looking at the amount involved, where we were looking at the complexity of the matter, where we would look at the impact that a specific case, if we were to have a takedown on it, will have. So we then, once we've prioritized it, it then comes to the way that General Makinyane was explaining, that we then form a team that will ensure that at least these specific ones that we have prioritized and we account monthly on are expedited. The last aspect that I thought it is important also to mention is that we do not leave any case behind, but those that we say we are prioritizing, we then put more resources to them. Meaning that you might find that the one case is still investigated by a single investigator. But those that we say in the NPCOC that these are priority, we then put a team on, but all of them, whether they are in the team approach or single investigator, they will still be guided by the prosecutor. I hope you got that. Thank you.
All right.
Chair, maybe to touch, I think there was a question on the matter that was found not guilty, and then there was the honourable member wanted to know what case. It is a case that involves employees of the department, the teachers of education in Limpopo, who then applied to the department for the scholar transport issues. It's just that now the details of why they were found not guilty, having been charged, is that what we are trying to get to those, because it can be either a technicality when there was evidence, but we are trying to get that maybe before the round of questions is finalized, we can have those details to respond. Thank you, Chair.
Thank you very much. Can I give Honorable Kubeka, Atkinson, and Maduna a chance?
Thank you, Chair, and greetings to the House.
Sorry, it looks like I've missed an answer. Sorry.
No worries, Chair.
I wasn't sure if we had answered Honourable Isak's question, but then to start with, I'm not sure if I fully understood the question. It was about the obscured line of instruction between the NPA and the DPCI. So I was just trying to understand so that I can properly answer you. Chair, through you, of course, sorry.
Yeah, no, look, early on in the presentation, okay, so the impression that I got is that there seems to be somewhat of obscurity, exactly as my question implies. So I wanted you to clarify, are there no obscured lines? Are you comfortable the instructions are open and transparent, or do you sometimes have difficulty in having to communicate these instructions? Simple.
Sure. Thank you, Chair. So, Makanyana has explained the prosecutor-guided investigation model. To be brutally frank, I think we need to properly interrogate whether this model is working the way it should. Because ideally the way it should work is, as the General explained, the prosecutor gets involved in a complex investigation, not all investigations, on very complex ones, at an earlier stage in the investigation. And ideally, that investigation should progress through, and prosecutors and investigators should also be on the same page, because they are meant to be working in a very coordinated way. But in General Lebia's time even, you'd find that the investigators are saying one thing to their line of command, and the prosecutors are saying something else to the prosecution line of command. And I think that is where you have these challenges. And I think, going back to what the chair said, unless maybe the IDAC is the prosecution-led model is perhaps the model that we should be looking at in terms of very complex cases, because, and we've been, General Lebia, and even at the national level, we've been trying to find ways of ensuring that at the provincial level, where the work actually happens, where the cases where the prosecutors and investigators are working together, what are the challenges with that model, and to see how we could actually improve that model, or to think about new models of how we do this. So we have incredibly good relationships. So that's no challenges with that. At provincial level, national level, coordination is good, working well. But I still do see a lot of challenges in the prosecutor-guided model, because you will have investigators and prosecutors having different understandings, yet if they are working in the team the way they're meant to be working on a case, all of them, everyone should be on the same page about this. But I think we need to interrogate this more, and to understand what are the strengths of this model, what are the weaknesses, and how do we strengthen the model if we want to get the best outcome. Fully understanding that prosecutors are not investigators. Investigators are investigators, and there should be skills, capacity, expertise in the police to be able to know what it's necessary to have a prosecutable, strong case. It should not be that the prosecutors are, of course, we will do that, but ideally that guidance should come from within the police. They should know, in order to prove a complex case like this, you have the experience, expertise. So the prosecutors has a minimal guiding role, not a major guiding role, because that investigation's happening in the SAPs. You've got the skills, expertise. But I think there's a gap there, so that we need to look into. So that's an important question, and I think we as entities need to interrogate this model carefully and understand what are the weaknesses and what are the strengths, and how do we build on it. Thank you, Chair.
Thank you. Just allow me to comment. This is exactly why I raised the question. Sometimes I would read a newspaper or an article or an op-ed, and I'd find it difficult myself to comprehend and understand as to what are these obscured lines. Why is it so? I sometimes think of the ordinary South African out there who wants to try and understand the dynamics of the NPA and the DPCI, and how does the SIU fit in. So this is why I actually raised this, because I needed to get some clarity, and I appreciate the frankness that the advocate has alluded to, that we really maybe need to look at this and come up with some form of simplicity or clarity. But I thank you again. Thank you, Chair.
No, thank you very much. Look, I think there is also a risk that I see where the prosecutor is too involved, in that the investigation might be misdirected, where the prosecutor has preconceived notions of what needs to happen from early on. I think ideally you want a sufficient detachment from the specifics of the investigation for the prosecutor to make the right decision. Otherwise, a prosecutor comes across a witness, potential witness they don't like, because they're just obstinate and crude, and that might affect, it might not happen all the time or like happen habitually, but I do think that guidance is okay. Too deep an involvement can be a problem. I think. Honorable Kupeka, sorry.
Thank you, Chair. And greetings once again to the House. Greeting honorable members. Greetings to the teams from the Hawks, the SIU, NPA, DPCI, IDAC. Chair, I think we've spoken about this, but I want to speak more about it. That any institution, Chair, that operates with more or less 50% of a staff complement is being set up to fail. It's being deliberately set up to fail. Now, I worry because I believe that the executives that run that institution, they've been there for quite some time. Now, if we've got a situation like that, that means that this is being done on purpose. And I don't want to be sitting here bashing the institution, but from the public's view or from our view, it looks very bad. If you've had people who've been working in the institution, who've been running the institution for years, and they know that there's 50% of the people who are supposed to be helping them function properly, and they're not functioning. It's a big problem, Chair, especially given all of the issues and the cloud that is hanging on these institutions. Chair, Advocate Batoy said that they cannot keep up with the competitive remuneration for specialized skills. We get that. Now, what has been done about that? What has she done about that? Has she come to Parliament to speak to that? Has she gone to Treasury to speak to that? Because then it means that they need to, have they not considered approaching Treasury to say, guys, we cannot keep up with the remuneration that the private sector is giving to people with these specialized skills. We need to up our ante. Chair, we know the NPA, it does not give confidence to the public in general now, after the lack of prosecution on their part. We have high-profile cases, Chair, and I'll just mention a few. We've got the state capture cases, a big issue. Still, nothing's happening there. We're told that there's 4 cases that emanate from state capture. 4. When R1 billion was spent by the Zondo Commission, we're sitting with 4 cases. We've got the Palapala saga. Nothing's happening. We've got Majela Koko's case. Nothing. Timo Motoso. Nothing. Bushiri. Nothing. Estina Dairy Farm. Nothing. Gupta Brothers extradition. Nothing. Free State asbestos scandal. Nothing. Along with the botched Morwadi Cholota case. Nothing. Cindy Somakaka case. Nothing. That doesn't look good. It says we've got a problem, Chair. It says we have a huge problem, and I think before we leave this House, we need to understand where is that problem emanating from. Out of these entities that sit with us today, where is the problem coming from? Chair, there are concerns about the NPA's capacity to deal with complex corruption cases with the potential for political interference. Now, as they sit here, there's a view, a very big view that is unspoken of, especially in this committee, because we tend to tiptoe around certain issues, that they are viewed as people who are politically influenced to step on certain cases and not on others. The NPA has faced accusations of mishandling cases and delaying justice, especially in high-profile cases. That too is a problem. In cases of poor people or people who cannot afford these fancy lawyers, those ones get prosecuted. And that's just a view that we now have of the NPA, and it's not a good look. Chair, again, on the national lotteries cases, I just want to know, and here's a question. Is the scope of the investigation going to be expanded given the issues that were ventilated in this House a couple of weeks ago, where there's a lot of other cases that we looked at when the NLC was here, the National Lotteries Commission? Or are those cases already covered in the slides that we got or that we received here today? On that 1 billion rand that was spent, Chair, on the State Capture Commission, are there any more cases coming from that front? And if there are no cases coming, Chair, should this 1 billion rand expenditure on the commission not be classified as fruitless and wasteful expenditure? That's a question for the team as well. And then, Chair, we have to ask ourselves that what is the core function of the NPA as it stands right now? Are they following people or certain individuals instead of following the evidence? Because you can't tell us that with the high number of high-profile cases that are not being taken to bed, that all of them seem to have a problem. Before the case is taken up and thrown into the media, is there not enough investigative capacity to determine that, okay, this one will be able to see through, so we take it on? No, this one we leave it because we can't take it on. Before you take people and you ruin people's lives, you put them in the media, they are paraded in front of everyone as these corrupt people, and then at the end of the day, there's nothing. Case in point, Matjela Koko. Matjela Koko was picked up at his house with his family, and they were taken in by, I think it was the Hawks, if I'm not mistaken, and the whole country believed that those people are corrupt. And then the Middleburg Commercial Crimes Court has just thrown the thing out, years later. Now, a lot of people they don't even know about what I'm talking about now, because it's not been plastered all over the media the way it was plastered when he was being taken into custody. Because now everyone believes that Matjela Koko is corrupt, but evidently he's not. So again, I ask, Chair, are they following evidence or are they following certain people? And then lastly, Chair, I wanted to ask, how secure is, now this is for the IDEC team. I heard that...
Members, please.
I heard that...
Honorable Kupega is speaking, so it's not okay to speak while he is.
Chair, I wanted to ask, how secure is any investigation, now this is for IDEC, that includes outsourced investigation capabilities? Do these outsourced investigating people, do these people sign NDAs? Do they have any security clearance? Do they need any clearance? Because if you are saying, okay, we're a specialized unit specializing in this, yet when we need to investigate that specialized item, we outsource. So when you're in that process of outsourcing, are these people vetted? Are they given security clearance? Are they made to sign NDAs? What is the process there? And then, sorry, Chair, I see there's one more point that I missed. On the Transnet Neotel contracts, I think the unfortunate issue here, Chair, is with having these issues taking prolonged periods of time to put to bed. You find the issue of Liquid Telecoms, it was also on the slides, where Liquid Telecoms is still operating in other government entities. And I say this because yesterday, actually, I posed a question to the Minister of Transport about Liquid Telecoms, asking them that there's a contract that they're running concurrently with, it was Data Centrics. One of those companies has been, the contract has been terminated at ESCOM, but they've been paid close to 100 million rand already, even after having been terminated. Now, if that company is Liquid Telecoms, the same Liquid Telecoms that's being investigated here, we need to realize and appreciate that these cases taking long to get dealt with is causing a huge problem, and the ripple effect is big. Thank you, Chair.
Thank you very much. So let me provide guidance in this way. So if you'll recall, Honorable Kupega said we'll deal with the DPCI first, and then the members after lunch will deal with the NPA. I didn't want to disturb your train of thought as you were talking. So please note all of those questions that are for the NPA. Then when we deal with you after lunch, then deal with you sounds bad. I don't mean it that way, but you get what I mean. Then please deal with the Honorable Kupeka. So to the extent that they apply to the DPCI, so please deal with those. Honorable Atkinson.
Thank you very much, Chair. In one of your slides, you went through the, thanks for the presentations, by the way, but in one of the slides that were shown to us from the DCPI, you gave the total amount of money being dealt with in these particular cases. And I think the two that were the biggest was the Department of Health, which was close to R1 billion in total. And then I think the Department of Education as well was pretty close to that. So my thought is if one does have an issue of capacity and capacity constraints, following the good old accounting principle of always looking for what can have the greatest effect, surely you should be focusing on dealing with those particular departments, because that does appear to be where you've got a problem. And the problem is if people feel they can get away with stuff, it just causes that stuff to grow. The kinds of actions to grow that actually add greatly to those amounts. So I would have thought specifically having a focus on your two biggest amounts in rands that need to be prosecuted, because that would actually help to kind of I suppose nip the bad actions in the bud, because they do seem to be pretty much concentrated in two departments in government according to that. Thanks.
Thank you. Honorable Maduna.
No.
I was joking when I said the Hawks were looking for you. You still look worried.
No, thanks, Chair. The first thing I was going to start by saying was to apologize to Hawks for whatever reason they are looking for me for. So, no, thanks, Chair. Good day, Chair. Honorable members and colleagues from DPCI and NPA and so on. No, thanks. I will also follow suit and be very short. I just have, I think one question will emanate from the fact that I think they said that they are going to prioritize about 500 posts for the upcoming financial year. Now, 200 being from internal. Now, I wanted to check, okay, should you get this 200 internal, are you already having arrangement in terms of where the posts that they will be coming from to keep them? In terms of the how you will fill them after we've employed this one to this new post that you will be advertising. I'm not sure if I'm making sense, but hopefully I am. And then I think in line with what the chair was saying, I think it's very important that the Directorate have forensic auditors of their own. Reason being that, once you involve external service providers in sensitive investigation, there's now an opportunity for some compromise and some biasness to take place in those investigations. So my first question would be, I think the chair would have asked it, but I would like to expand further, because I would want to understand really in terms of this, how do you sit down and and decide that this should be prioritized from this. I think it's very important that I get that in a much more clearer sense. And my second question is that how do you measure the effectiveness of your investigations, and what metrics or benchmarks is it using to assess its impact on reducing priority crime? What indicators do you use to evaluate the success of your investigation, and how do you use this information to refine your strategies and improve performance? The second question, which will be the last one, Chair, I wanted to check. What measures are you taking to ensure that your investigations are intelligence-driven, and how is it? How are you using data analytics to inform your investigation strategies? What sources of intelligence do you rely on? And lastly, how do you validate and verify intelligence to ensure that it's accurate and reliable? Thank you.
Thank you. Over to you.
Thank you, Honorable Chairperson and members. May I start with the Honorable Kupega? When we got the invite, the focus was on matters that are referred to NPA and ourselves by SIU. So when we give figures like that says 4 state capture matters, that is not to say we're investigating 4 state capture measures. We were referring only to those where there is a referral. The same as the Honorable Member mentioned of the National Lotteries Commission. That 7 are only the 7 with the referrals. Thank you, Chairperson. A question was asked about the vetting when we outsource our investigation, when we don't have the resources in-house. We do sign a non-disclosure agreement with that outsource, but we do not issue security clearance for them or cause them to be issued with security clearance, nor do we vet them. But the safety measure that is in place is that most of them belong to some professional bodies where if they were to break the confidentiality clause, it would risk their future. So I think that serves as a safety net, that they would not, and we haven't had the contravention of the agreements that we have had with them in the past. But I do agree with yourself and the Honorable Maduna as well when it talks to that once all is insourced, once we could do them in-house, that will be far better and a preferred way of doing things going forward.
Sorry, may I just ask, so you do no background checks at all on the people that are going to handle the case? I mean, I understand working with a forensic outfit, right? But surely you also want to make sure that the specific individuals that are working with it don't have other problems elsewhere. Let's say somebody has a gambling problem, and that makes them susceptible to being paid money to provide information or to, you know what I mean? You get the risk I'm trying to say. So it seems worrying that you are suggesting that the specific individuals that get forwarded don't then undergo any kind of background checking at all. You rely on the professional bodies to which they belong to punish them later if they happen to do something.
It is something that we should really look into, Chairperson, but at the moment it is not. It's something that we need to
okay, so please do.
Indeed. Then there was, I think my colleague will speak to the issues that talks to liquid telecoms, if it was in your presentation, sir. Then there was a question that was raised by the Honorable Atkinson that speaks to the value. Maybe I don't want to keep on repeating, maybe I might bore you, but what I wanted to say is that the collective that sits in the NPCOC prioritize, and the value is one of the aspects that is considered. As I mentioned, it's the value, it's a public interest, and the possible impact that the success could have are the considerations. So the value is definitely included in that. The Honorable Maduna asked the question, what is our plan for the replacement of those that we possibly will promote within the system, creating a vacancy? Honorable Chair, what we will have to do is that amongst those that will be taken from within the system, it's similar to the question that was asked by the Honorable Mentor. It is inevitable that there will be posts that when we promote people will become vacant. Those we will fill up with the next round, but also there is a possibility that we might get applications from the bigger SAPS coming to us, and then that question of a gap becomes that of the bigger SAPS than ourselves. I think I've spoken to the prioritization and the external role players. I think the question there from the Honorable Maduna was similar to that of Honorable Gubega in terms of the risk that it carries, and we have agreed that it does. And therefore, the correct way going forward is to utilize our own in-house. And then my colleague here will talk to what indicators I use when we deal with the intelligence. Thank you, Chairperson.
Thank you, Chair. Maybe, Chair, let me first indicate the companies that were mentioned by the Honourable Member, those Neotel. They are not in our presentation. They are in the presentation of the IDEC. So I'm sure the IDEC will respond on that. Now, the issue of the intelligence, yes, the DPSI is supported by crime intelligence on the investigations, though because of these resource constraints, we are not supported to the level where one would be happy of. But there are matters that are supported that comes from the intelligence, and they are supported by intelligence throughout in the various spheres of investigation, like the crime, the commercial crime, the organized crime, and the serious corruption investigation. So the other question of the honourable member was how are we looking into the effectiveness of our investigation. The DPSI is also looking into, as the mother body, that is the SAPS, we are looking into the detection rate on the cases that we are doing. We are also looking into the successful, what is the conviction rate on the cases, which does not necessarily that we look into on our own only, we jointly with the NPA. But more specific on us is the detection rate that we always look into the percentage of our successful investigation on the matters. It is true that our matters take very long, Chair, which is not what we always like, but it is the situation that we're in, the resources issue that comes into play. Thank you, Chair.
Thank you. Honorable Skosan, I'm looking at you.
No, thank you very much, Chair. And good afternoon. All protocols observed. Yeah, Chair, I want to start...
Sorry, Honorable Skosan.
I was wondering if I misheard you. Will NPA respond after lunch on all of the issues? Thank you.
Yeah, Chair, I will start with a comment and then come to a very few questions. I think on the matter that was raised earlier in relation to a need for legislative amendment in order to reduce the turnaround time for handling cases within the ecosystem. Because definitely I think the current situation is a serious challenge because a proclamation is issued to the SIU. The SIU, they take their time investigating the matter, and then the matter get referred to the NPA. Now the NPA, well, because they are not only dealing with SIU matters, they've got quite a lot of work that they are dealing with. So SIU issues just become part of the lot of work that they are doing. So they take their time before they process those matters and look at them, and then refer those matters to the DCPI. DCPI take their time investigating those matters, and then after investigation, those matters go back to the NPA again. Then they are piled there in the NPA because they are handling a number of issues, the NPA. Then at an appropriate time, then the NPA will then take a decision whether to prosecute or not. It's only at that stage that then the matter goes to court. So it takes very long. And I think it's one of the reasons that in some of the cases which the SIU have seen a potential for them to be winnable, but when at a time the NPA has to take a decision, you find that at that time there's no longer a tangible evidence, and then the NPA will end up saying, no, we don't see prospect of winning this case, or we don't see tangible evidence that can be used, because it will be maybe after 5 years. You see, might be after 5 years, because this thing started at the SIU level, it went to the NPA, from the NPA to DCPI, DPCIS, from DPCI back to the NPA. So because of that time, because of the period that it takes for all these things, obviously it will affect, in some cases, it will affect the evidence and all that. So I support the view that there should be a legislative amendment in the ecosystem of handling these cases. Now, I see a DCPI that amongst some of the cases that we're dealing with, there's an issue of national treasury, where there's only one case which is under investigation, but the case amounts to 1 billion rands. So I just want to find out what is the case all about. It amounts to 1 billion rands. Secondly, with regards to municipalities, I see we've got 35 cases where municipalities are involved. 14 of them are under investigation. 17 of them are submitted for a decision. And then only 4 are at the court docket stage. Yeah, well, my concern here, because on the only 4 cases that are at the court docket stage, they only amount to a tune of about 3.9 million rands. And when you look at the cases that are still under investigation, they amount to about 349 million rands. And cases that are submitted for a decision, they amount to 437 million rands. So I don't know how old are all these cases, but cases that are at the court stage, they only amount to 3.9 million rand compared to the other 2, which is 349 million rands for those under investigation and 437 million rands for those that are submitted for a decision. So I don't know how old are these cases. Maybe you can tell us, because I think it doesn't give us comfort, because it looks like the input, when you compare the input and the output, there seem to be a serious discrepancy that very few matters get finalized, and then quite a number of matters are still either at the investigation stage or still awaiting a decision on the part of the NPA. So I think it doesn't give a very good picture that is encouraging. If you have cases that only amount to 3.9 compared to cases that amount to more than 400 million and more than 300 million, you see, it doesn't look good. Maybe you can just elaborate as to how old are these cases and what are the challenges with regards to that. And also with regards to the COVID-19 cases, where you've got about 93 cases, COVID-19 related cases, and only 22 are before the court, 12 submitted for a decision, and 59 still under investigation. So cases that are still under investigation, they almost constitute 2/3 percentage of the total, because it's 59 out of 93. And COVID-19, I think it's something that happened 4 to 5 years ago. So it also doesn't give us comfort that 4 to 5 years later, 60% of the, about 66% of the cases, they are still under investigation. I don't know, maybe they constitute what you earlier referred to as complex cases. I don't know, maybe you can elaborate on that, whether these cases that complex that it makes you to take so much time to conclude them. And then lastly, Chair, with regards to the shortage of staff, I just want to make sure if I've captured you well as to that. The reason you've got a shortage of staff, it has all to do with with your low remuneration package, which results in high staff turnover. That when your staff members see greener pasture somewhere else, they easily leave because of the low remuneration packages. Is that the main reason that you are standing at 50%? Don't you have a a resources challenge? Don't you have a budget challenge that you are unable to fill other posts because you don't have money? Is it just because of the issue that the remuneration packages are low and therefore people don't stay immediately they see greener pasture somewhere, they easily leave? Thank you very much, Chair.
Good afternoon, Chair. Good afternoon, colleagues. Good afternoon, our advocates and the head of the NPA, DPSI, and all present. I have quite a few questions that I wish to pose to you. And one of the areas that I wanted to post to ask is that I've not heard any word that says turnaround strategy. There's been collaboration between different departments, but one would have thought that you would have presented a turnaround strategy. And then my next question is, and do you have a comprehensive and cost strategic plan? Because if you are to collaborate with all the different departments or the different divisions, one would have then come together and said, look, let's draw up a master plan now with everything and all the different elements so that you can navigate your way forward. And with that plan, it then also tells you how you collaborate. Because my next question is going to be, if you have an MOU with the SIU, why are you not using their resources? Surely they have spent years, and I'm saying years, on gathering evidence. Now that evidence, first of all, they would have had information that would have got them the proclamation. From that proclamation that is signed by the President, it then that is giving you that there is obviously where there is smoke, there's fire. So that goes there. From there, it is investigated. It could take a few years, which we've seen. It is absolutely a lot of information. Why would you not then collaborate with them, use that information? Because it is obviously thorough. Because they would never have given it to you in the first place if they didn't think there was a case. And that is why you would then, why would you want to go and investigate? Surely you would take that information and then just add the missing pieces that you would want to go to court. So the other thing is that you said if the SIU also have facilities or they have procured facilities to get all that information, which you talked about, the terabytes of data, they would give it to you. So they would be able to sit with you and unpack it. Because there is a directorate that has spent years gathering that information only for you to say, okay, now we start again. So I don't understand that. And then in your MOU, and maybe I'm missing something, why would you not collaborate more closely with the SIU? So that you are the springboard, because there's the triangle. The SIU is at the top, NPA is on the side, the information goes to NPA, then it goes to the DPCI, and all the other directorates working very well with the asset forfeiture, because after lunch I have some questions on that side. With your strategic plan, if you're talking about your cyber crime, would you not then, as SAPS, say that's the area crime intelligence would deal with? So that there's a collaboration, because what we are seeing is disjointed information, disjointed structures. And I come from public safety, so I know what I'm talking about. So the other area that I wanted to touch on is that exactly what my colleagues were saying, there's 200 internal posts. I have a problem with that, because I already see in the area that I come with, those that have come from the ranks to the Hawks sometimes are compromised, because one of the areas that you've got organized crime wanting to put their own in the Hawks, okay? And I can tell you now there's infiltration. I mean, you haven't managed to come forward with 180 cases of kidnapping. So if you can't even solve kidnapping, how are you going to solve these cases? And some of those cases are managed by the Hawks, who are, some of the members have been compromised. So those are areas. So one of the points that I would like to say is lifestyle audit. Have the Hawks themselves gone through the process of lifestyle audit? Everybody in there. Security clearance of your own. Do you, just because you are the Hawks, do you have a security clearance? It's different when you take officers, which I've seen in my own experience, from the ranks. They think it's great to be on the Hawks. You know, they're like cowboys. Because when you are in the Hawks, you need to be strategic in the sense of the kind of criminals that you're dealing with. You can't have cowboys out there and thinking that they can go and just be loose cannonballs. You actually need to have strategic members in the Hawks that have the background, as we were saying, that have the CA in law, but at the same time, you would have those that are operational within your side, that are good at tactical operations. And we've seen some good cases, but it's been from SAPs who have actually caught the criminals, not so much the Hawks. It's when they've collaborated with SAPs, they've actually, unfortunately, those criminals, as soon as they shoot back, they're shot. But what I'm saying is the cases, we want to see a success. We want to see those cases prosecuted. My last question, Chair, which is my favorite one, is the cottage industry for lawyers and accountants. Are you now going to open another door for lawyers and accountants to assist in any of your, if you are going to be sourcing some of your work out, okay? Well, what we have seen here in Scopa is the cottage industry for lawyers that are now suddenly looking at coming into that kind of role. In the Eastern Cape, we have seen collaboration between lawyers and prosecutors, okay? So my question is, how are the collusion between your prosecutors and the lawyers coming to the finalization of a case? No, there's not much evidence here, when in fact the evidence is there. It just possibly hasn't been unpacked properly because the SIU has done that homework. All you have to do is put the cherry on the top and go to court. And so those are the challenges and the information that I wanted to see. I have a lot of questions, but I'm sure it will then all feed into the NPA. Thank you so much.
Thanks, Chair, and greetings, everybody. So I don't think I have any questions, but mine's just more a comment. And I just think there's a total lack of political will to fight corruption. I just looked at some figures now. In 2023, the VIP protection had a budget of 3.8 billion. It looked after 200 people. With the bloated cabinet, it's probably more now, looking after more people. And the Hawks, in the same time period, had a budget of 2.2 billion. So a budget of 60%, but it was to fight corruption for 60 billion people. So, Chair, until there's political will to fix this corruption, until the Hawks is properly staffed to fight an organization that is 50% understaffed, you're whistling in the wind, you got no chance. Your guys are overworked, you're understaffed, under budgeted. You're fighting your tails and you got no chance. And our commitment as Action SA, we will do whatever we can do to ensure that you're properly funded. I mean, I've sit here in Scopa sometimes. The RAF, it's a 50 billion cesspool of corruption. Yet the Hawks gets 3 billion. I mean, it's unbelievable. You could fund yourself but there's just a lack of political will. Until there's political will, we're whistling in the wind. Thank you, Chair.
Thank you. Over to you.
Thank you, Chair. Chair, I will deal with the questions and then those that my Divisional Commissioner will then finalize the other questions. Let me first, Chair, indicate on the Honourable Member wanted to know which case of National Treasury that has got an amount reflected as 1 billion rand there. It is a matter that involves the appointment of Oracle, which was referred by the SIU by appointment by the National Treasury. That is the amount that is the case that is under investigation for the National Treasury. And then there was also a comment from the Honourable Member on the issue of the evidence provided by SIU in the cases. The evidence that SIU provides, DBSI works from there. The SIU will always provide an affidavit that talks all the evidence that they feel is pointing to the criminal elements on the case. Now, that statement alone still needs to be supported by investigation, still need to be collaborated through various statements or individuals that would have been mentioned by SIU. That is the investigation that now starts immediately the SIU have referred. I am referring to that in a matter which was not necessarily in the space of the DPSI before the SIU make a referral. So the evidence of the SIU is taken into account and you work and add on that. The vetting of the DPSI members, the legislation requires that the DPSI members should have the security clearances, which we have, but unfortunately we don't have that clearance, all of us, because of the delays and the challenges that crime intelligence is having. But it is the requirement by the legislation that we should have security clearances in the environment. I think it has been indicated even in the past presentations that we at times even lose the potential candidates when there are vacancies, especially on the senior management, when we could not appoint whoever that have been interviewed and qualified to be appointed simply because he does not have a security clearance. The process takes too long. Then the issue, Chair, of the outsourcing is not new in the DPSI, and it's not new. We have been doing that all along. And I think the Divisional Commissioner indicated that we make sure that those companies that we are outsourcing for the skills that we don't have within the DPSI, it has been there more on the auditing space. The entity that the DivCom talks about that has got 2 chartered accountants and those who are 16 now. It is a new entity that has been formed within the DPSI in the last 3 years. And the purpose of developing that is to, in a long run, to do away with the outsourcing. So we make sure that those companies, they sign the confidentiality certificate to ensure that whatever we share with them should not be shared as they wish. So those are the questions that I will just deal with them. I'll give to the DivCom. Thank you.
Thank you, Chair. The question by the Honourable Member Skosana was that when we say of the shortage, is it only because of the pay? No, that is not what we were saying. If it came that way, it would have been not our intention. We were only speaking to the scarce skills section where we were talking to your chartered accountants and the security, cyber security space. But in the others, what makes shortage in the rest of the organization will be the natural attrition, people retiring or others unfortunately passing away. And then maybe our recruitment process is not quick enough to pick up the pace so that we can replace all those that we lose and also in the process grow. that has been the problem, but not necessarily that it was the salary that created the problem. Thank you, Chairperson.
Nobody's volunteering to comment on whether the cabinet is bloated. None of you want to go there. Any takers, Advocate Motibi? No takers, no.
It's career limiting, that one.
Honorable Kupeka said we tiptoe here. We are tiptoeing now. Okay, honorable members, the time is 25 to 2. So can I ask that we are back here at 10 past 2 so that we can then take it home? It will be the NPA's turn. But nobody's being let off the hook yet. You stay because the questions cross over. Thank you very much. Sorry, Honorable Beasley. They didn't answer your question. I am told that the lunch is there's lunch downstairs. Thank you.
assumption that there would be internal controls that would pick up these things, that because you here we've had a problem with you in terms of your conduct in particular case 1, now we can't find you in particular case 2. This chair is in line with the recently published affidavit in the case of Cindy Somakaka. A young man that died very young from a rural town in Mzumkulu. Cindy Somakaka, when he was shot, it was not only the only person that was shot. There were a number of many other comrades that were shot. Yom Tutuzi Chibas, the former speaker, the speaker of Mzumkulu municipality of that time, which was Kaya Tobela, Cindy Somakaka, there were many others who would have passed on during that particular period. Now, it's very sad when one of the person that would admit into taking part in the killing would make allegations that he tried making or depositing this affidavit into evidence as far back as 7 years back. But the investigate or the team that was the prosecution team from the NPA denied him the right to do so. It tells you that we have a problem. Now, I think my question is in line with the above. What internal controls do they have within the organization to ensure that people who perform these things that are either prostituted or part of their employees are dealt with and do not again form part of other high profile cases? And I think it's a really sad, Chair, especially in the issue of the former SG of the Youth League, Cindy Somakaka, because I think one of the things is that I'm told late last year there was a visit from unnamed people to his mother, even though the son passed on many years ago. That raided his house because they were looking for documents that he would have held in his possession before he passed away, where he would have exposed particular individuals for corruption. So if you don't close that case, it means that woman will continue to be abused, like it appears like it's currently happening. Really, I think online with the Omotoso, with the recent loss of NPA in the abused case, I think NPA has basically suffered a reputational damage. I think it's in line with what the chair is saying. That you must be welcome to the coach's job, whereby even if you can play the whole season, you win many games, but if you don't win the league at the end of the season, we fire you. Unfortunately, that's just how it is. So I just wanted to start there. It really worries me, especially advocate around the high profile cases. If you look at the Etegwini, the former Etegwini mayor case, other writers used to say a justice delayed is a justice denied. So it's very important that we deal with these cases, especially the ones that are high profile, because these are still people, they want to continue with their lives. They want their fate to be determined whether they are guilty or not, so that they can continue with their lives as well. Now you see, when the case will be ongoing for many years with no resolution, it hinders with progress in their lives. I think that was one. I wanted to check also, because in terms of the referrals, Chair, even other departments besides the SIU and so on, departments from Zegelo, I know the Department of Water and Sanitation recently reported to us that there are some cases that they would have opened with subs for. So I just wanted to check there, to have any system, these other departments, those that are not only from SIU, because obviously you would have good people in municipalities and government departments, directors that would say, so and so have done wrong, let me take this to SARS, then obviously it's transferred to you to prosecute. Do you have any system to ensure that in the statistics that you do, you take into account those cases as well? And the statistics as well that you would have done of the cases in terms of the delay, in terms of what usually contribute to the delay of cases. Can Chair, if possible, if there isn't anything that is hindering us from getting that statistics, can we receive it so that we can be able to go through it? And lastly, Chair, I must just state that it really worries me that the DPCI would award, because I believe that these service providers to provide them with such things such as forensic accounting and so on, to people that they would have not vetted. Why I'm saying that? If tomorrow I am a minister, it tells you that I have a proper network. Now, if we are going to add, if a case involves me, I'm just making an example, involves me, it means I have a big team that is behind me, that is trying to help me sort out that. Now, if you are going to appoint a service provider to come and perform particular forensic in maybe weather or accounting services for you without vetting them, what happens if one of those people is actually a close friend of mine? You know? And unfortunately, you can only perhaps find out when you get to court. You know, when lawyers start arguing and then you start finding out that the person that assisted you in doing this investigation is my friend. What then happens? So it really worries me, Chair. As well as the integrity of the investigation, it puts it into question. Thank you.
Yeah, like the chair finding out his cousin is in the room. That sort of thing. And having to make a quick declaration on the spot. Can we start with Honorable Kubeka's questions? Thank you. Over to you, Advocate Patwe.
Chair, I'm going to first hand over to Advocate Johnson, the head of IDAC, to deal with those questions, and then I'll sweep up. Thank you.
Honourable Chair, honourable members, and to colleagues from the SIU and the sister agency, the DPCI. Honourable Ndate Kubeka, you raised some issues that do pertain to IDAC, but then some of the general questions that have an investigative component to the DPCI also relate to ourselves, Chair, and I seek to perhaps be given an opportunity to deal with those. So, Honourable Kubeka, on the issue of IDAC only having 4 state capture cases in court, I thought I would clarify the SIU referred 10 matters to IDAC. Of those 10, 3 are in court, 7 under investigation. But if you take the state capture cases, IDAC currently has 37 state capture cases on the roll, plus 13 other corruption matters on the roll, bringing the total to 50 criminal matters on the court roll. I just thought I would clarify those. And I do take the point, Honourable Chair and members, that oftentimes matters seem to have failed. Unfortunately, we have had this discussion as well internally, is that there are certain things that we do not come out and say, as was the case in the New Lane matter. Part of our ethics and profession means we run process, and in the end, the process must speak for itself. And so you would not have found the NPA going out and making any negative comments, per se, about the presiding officer in the matter. You take the matter on appeal, it gets dealt with. So similarly, if you take the Gupta extradition, for example, and yes, we are criticized for having failed that extradition, and we didn't fail the extradition. When the UAE decided not to extradite the Guptas, Chair and honourable members, we wrote to them, we have to follow a process. 12 note verbals later, we still do not have any response from the UAE about why the extradition failed. safe to say that they have asked us to resubmit. Now, how do you resubmit when you've submitted a full set of papers, properly checked, even by themselves? So it does put you in somewhat of a predicament. Do you now send these papers for it to be a so-called failed attempt again? We have now, however, taken a decision to submit new applications with additional matters. The country also cannot sit and wait while the NPA, unfortunately, has to follow a legal process. So having taken that into account, the public interest and the interest of justice, we will submit new applications, but not just for the matters that we had applied for, which was Estina and New Lane. We are going to apply for extraditions in relation to other state capture matters. And I just want to be clear about...
Sorry, may I ask, because I think, for context, has there been any other criminal prosecution, and this might be for Advocate Mzinyati and you as well, because it's not, this is a general question, where you've had to extradite, to have somebody extradited from the UAE? Is it generally difficult in the manner that it has been, or there is basically there's an exception here? That's what I'm trying to establish, if you know.
I can indicate, Chair, it's generally difficult, and not just for South Africa. So when we engage on such matters, and especially matters where we have foreign jurisdictions, we actually do engage with some of our international counterparts, and from the UK to the US and other jurisdictions, it has been a challenge. Getting extraditions from the UAE. So we've tried to do lessons learned, look at the best practices, and unfortunately, that is where we are. And then to indicate, for example, on the cocoa matter, I just have to be very clear. At no stage did the state parade Mr. Coco. Yes, there would have been pictures of Mr. Coco, but Mr. Coco appeared in a public court, and the media is allowed in court. And it has never been our modus, nor will it be. And if it was seen that way, it is unfortunate. But he was not singled out, Chair. So Mr. Coco, together with a host of other individuals, was arrested as part of a matter. We do not single out any individual. We have to follow the evidence. And what we put an accused, and not just him, what we do put an accused before court on are allegations. Their guilt and or not must still be determined by a court of law. And so we have to follow the evidence. We do not follow profile, and it becomes extremely important for the people of our republic to understand that we make allegations, they appear on a formal charge sheet, they appear in an open court, entitled to legal representation, and a court process is then run. We did allude to this, Chair, that we did have challenges in that matter, and there are legal processes with regards to the presiding officer that are being dealt with by the Magistrates Commission and the Legal Professions Council. And because they currently sub judice, I cannot allude to what is actually happening. In terms of potential for political interference, and they pick certain cases because they are influenced, I will say adamantly and vehemently, absolutely not. Not in the IDEC space. No one has tried to interfere. And I dare them to interfere because ours is an oath and an independence that's guarded by the Constitution, but by integrity of self and the institution. But what I'm alive to is one cannot say there would never be an attempt. If anyone has evidence, it should be brought to the fore, because it is important that we are seen to be able to do our work without fear, favor, or prejudice, Chair. I wanted to deal with this aspect that was raised with the DPCI, Honorable Kubeka, but because it might also relate to our space, on how do they secure investigations where services are outsourced. So in the main, I think together with the DPCI, one of the aspects where you find outsourcing would be the forensic investigations and digital forensics. In IDEC, they sign a Section 41.6 non-disclosure, which is Section 41.6 of the NPA Act, Chair. In fact, every single project and or teams meeting or meeting of the teams, when it takes place, the attendance register has on the right-hand side a reminder of the non-disclosure, and that details of that meeting and every meeting to follow do not get discussed or disclosed. I am aware that the supply chain management process of the NPA, they do run a risk profile. They do give us a heads up if there might be something we have missed, and we are asked to go back and relook at a different service provider. Perhaps in addition to indicate that in the IDAC space, we do have matters relating to state security, and the entity that actually looks at those matters were top secret cleared by state security themselves, just for purposes of finalizing that gap. And then the last thing, Honorable Ndate Kubeka, was on the Neotel liquid telecoms. Just to be clear that the corruption we are looking at relates to Neotel. Liquid telecoms, unfortunately, inherited Neotel. So they not only inherited the liability, they have to come and talk to us about the criminality that would have been done by Neotel. But if there were any allegations of criminality in any of the matters we are currently dealing with, which in this instance is Neotel/Liquid Telecoms in the Transnet sphere, Chair, we would most certainly look at those. No one is an exception to the rule, even if you are talking to a party. I hope, Honourable Kubeka, that would have dealt with some of the aspects that were raised. Thank you, Chair.
Thank you, Chair. And I'll perhaps just deal with one or two issues that were not dealt with, or just for emphasis. So, Honourable Kubeka, the issue of I think you put it really nicely when you said we must really understand where is the problem coming from. And I think that is critical, because if we don't properly understand the information and the facts, we just base our opinions on things that are out in the media space. It's very difficult then to properly identify the problem. And so understanding the problem of complex corruption, as you put it, is so critical. And the role of law enforcement in this is hugely important. And I'll deal I'll just emphasize what Advocate Johnson just said about the potential for political interference. Through you, Chair, just to really emphasize that it's not only that our Constitution requires us to do our jobs without fear, favor, or prejudice. As individuals, each one of us here, we took these jobs because we believe in the rule of law. We believe in accountability. We believe in justice. And it doesn't matter who it is. The rule of law means it doesn't matter who it is. If the evidence points to and establishes that someone, on the evidence that we have, is guilty of corruption, of course, or that the probabilities of a successful prosecution are there, we will prosecute. And it is our individual integrity that is so important. But that doesn't mean that all prosecutors in the NPA, in fact, work this way. We certainly, and I will advise you of some of the steps we put in place to try to ensure that, because it's hugely important that we have prosecutors that don't only just mouth without fear, favor, or prejudice, that they actually behave and do their jobs in accordance with the oath that we take. So the understanding complex corruption, I just want to make this one point. As law enforcement and prosecuting authorities, we have a huge role in the country being confident that we are addressing corruption. And we've dealt with a number of challenges, and I will come to that in a second as well. But unless we understand what is the real cause of corruption in this country, that the lack of systems, processes, ethical leadership, and good governance across government entities, whether it's on all the levels of government, that is what causes corruption. And unless we address that, I'm glad that with the OPI, potentially the NACAC has actually, the setting up of this new entity that's going to look at systemic corruption and how to deal with that. I think that will really have, because unless you prevent corruption up front, we in law enforcement can be blamed for it. And I know I do not want to minimize how important it is that we do hold people accountable, that the people see that those responsible for corruption are being held accountable. But unless we see it as law enforcement is part of a much bigger strategy in terms of our national anti-corruption strategy to deal with corruption, we will never be able to prosecute ourselves out of the problem of corruption. unless we have preventative measures up front. So, and to give the assurance that I think Andrea's dealt with that political interference. I have not had the executive in any way attempting to influence the prosecuting authority to deal with cases or not to deal with cases. With regard to cases against the poor, I want to say to Honorable Kubeka, there's one thing that I take from Vusi Pikoli, the previous national director, and he always said, always have a bias for the poor. And that is what we want to, as prosecutors, we want to make sure that we are there to help the poor, the vulnerable, the marginalized in communities more than the rich and the powerful who can influence. So that is what we really want to do, is to serve the victims across society, no matter where they come from. You're right, Honorable Kubeka, that the NPA has taken a knock in terms of confidence of people in its ability to do its work. And I'm hoping that I'll just hold with that. But the reasons for this, and you mentioned a number of the cases, Pala Pala, Koko, Omotoso, Bushiri, Estina, Asbestos, Gupta, Choloto, and the Sandiso Makaka cases. And I'll leave the last one for our colleagues in the NPS to deal with. But I want to implore, and the reason why I say this, I want to implore the committee and the people of the country not to judge the success or failure of the NPA on these very important cases. And I'll go through each one of them and I can explain where they are in a legal process so that we can understand what happens. And the danger of coming to conclusions before legal processes was so clearly demonstrated in the New Lane matter, which was the first case, that state capture case, that the NPA, in inverted commas, lost. And we were absolutely, from the national director to the prosecutor, we were denigrated, I think is the word, in that matter. Many of you would have seen the Amabungane documentary, where the national director and many prosecutors, that is the best word to use. New Lane was the linchpin that were used to lynch us. And it caused huge damage to the NPA. And what's happened now is Supreme Court of Appeal has completely overturned that decision. We believed in the case, we believed in the prosecutors, we appealed that case. And the Supreme Court has seriously criticized the judge in that matter in terms of how the matter was approached. And now what do we have to do is retrial before a new judge. And that disadvantages witnesses who have testified, who have to testify again, and there's a whole lot of challenges with the retrial. But we have to deal with that and go through that process. The point I make is that let's allow legal processes before we decide on success or failure of the NPA without allowing these processes to unfold. Advocate Johnson's dealt with the Koko matter, the Omotoso matter. The NPA is doing such incredible work on sexual and gender-based violence cases. This one case, a hugely important case, has really set us back. And I dealt with that, and I don't want to go into any details because when I answered, I think it was Honorable Trollope earlier on, I dealt with that. But this is a matter that is on appeal. The Estina matter, Advocate Johnson is...
Sorry, may I interrupt you? So, when you explained what's going on with the case, I then also thought, well, we hurriedly deported the guy. So now I'm thinking, okay, so we're not going to get him back now?
Chair, this was...
and I'm not blaming you, I'm just now wanting to understand how that... the speed with which he was ejected made a lot of people happy, but now it's clear that he's gone.
Chair, let me say, it's a no-win situation. And I want to just emphasize that, yes, he's no longer in the country. We are appealing that matter, right? So an appeal process can take years. And so, it's, as I said, it's a no-win situation because he could have still been in South Africa, enjoying his life in South Africa, while the victims feel that they've been denied justice and the person they feel is responsible for their pain is still here, enjoying life in South Africa, doing things that he wants to in South Africa. The fact that he's had to flee from South Africa means he's not been able to live his life the way he would like to. In the meantime, the appeal process could take years. Nigeria is a country that we do have an extradition treaty with, and there are also other multilateral treaties that we can draw on to hopefully bring him back when we do. We have been successful with many, many extradition applications across the world. The UAE is the one that sticks out, and we've had challenges with that. But generally, we are reasonably successful with extraditing people from other parts of the world. So hopefully the Nigerian government will be amenable, and we'll be able to bring him back to face trial once if we are successful in the appeal process, because that is also, we've got to wait to see what the outcome of that will be. Chair, so the point I make is we can deal with all of these cases where the NPA has been seriously criticized for. And I want to say the following, and the only reason why I say it is because it's important for people to understand what exactly the NPA is doing and why people should not lose faith in the institution. Firstly, our performance over the past 4 years has increased from 50% to close to 75 to 80%. Secondly, the asset forfeiture unit, the freezing orders, which Advocate Rabaji Rastaba explained, and the final orders, if one looks at all of these orders from the inception of the asset forfeiture unit until now, between 45 and 48% of all of those have been obtained in the last 4 years, which gives you an indication of how extremely well the asset forfeiture unit is doing in this space. We can look at sexual and gender-based violence. The Tutuzela care centers, which is a world-class best practice, where victims on their road to becoming survivors get the best support services, in fact, compared internationally. And so conviction rates in respect of those matters have gone up from about 60% to about 75%. So I can go on in terms of all of the good work. And the only reason why I say this is because I want victims of sexual and gender-based violence to know that they must speak out and they must come forward and they will get the best services. And so those are, to deal with the confidence issue that Honorable Kubeka raised, I think it's important for me to show that these are the things that we are doing in order to ensure that the victims get justice in South Africa. With regard to, Advocate Johnson dealt with security of investigations that are outsourced, and so did my colleagues from the DPCI. But I want to emphasize the problem with security vetting in this country. It's so easy to say, have people been vetted? But I want to ask, how many % of crime intelligence people are not vetted? How many percentage of state security people don't have top secret clearance? We must ask these questions. And I think that the answer might be worrying. But let's ask these questions, let's get the facts. And those are people that in themselves must vet institutions in our space. It's a bit, so I think we need to understand, but I do not want to detract from the criticality of security vetting and the ability of the state to do it fast. We have prioritized, we've been working with SSA, I want to hasten to add, we've prioritized, we've given them key people that we would like to be vetted quickly for various reasons, and we've been getting good levels of cooperation and success from SSA. But across government, this is a huge problem. So security clearance, and just to say that many of the people that we work with do not have access to top security documents. It's only, for example, the investigators in the SSA matter that Advocate Johnson spoke about that are accessing top security documents that need the top security level clearance. Otherwise, it's not required. Confidentiality is sufficient level of clearance for people to be able to do their work. With regard to I think for now, let me finish. So Honorable Kubeka raised one other question about staff complement. Just to say that in the NPA, when I took office, we had a vacancy rate of about, in the specialized units that needed to deal with corruption and that's the SCCU, Specialized Commercial Crime Unit, and Asset Forfeiture Unit. We were sitting at around 25 to 28% vacancy rate. But we went on a very aggressive, well, firstly, budget advocacy, because we needed the money. And there were questions around budget, which I will deal with now as well. And we did get the money that we needed from government. So there's been commitment to support the NPA. And we have been on a very aggressive recruitment. We started the aspirant prosecutor training program, which is those straight out of university come through and go through our aspirant training course. And that had been stopped in around 2016. We started that again. And so we bring in students from university, we train them, and they become prosecutors. And now our vacancy rate in the NPA is sitting at around 10%, which is quite acceptable. And so I want to say that we have really been, and your other question was, how do we deal with the competitive remuneration skills? What have we done as the NPA? We've actually done a job evaluation already. We've submitted it to the minister. And there will, of course, have to be engagements after that with potentially, well, with Treasury, DPSA. But that process we've already started to make sure that we can hire those skills at the right salary level, so we can also retain them. At this point, I'm going to hand over to Advocate Mzanyati and Advocate Kanyana to deal with some of the NPS issues. And I don't know if there's some asset forfeiture issues, and then I'll come back to matters that are still outstanding. Thank you, Chair. May I, through you, Chair, of course, Advocate Mzanyati.
Thank you, and thank you, Chair. Chair, the very first question you asked when you opened up for question time was whether, there is any skills deficit at the CCU that should worry us. Well, I wouldn't say there is a Chair. The best indicator for me, where I'm sitting as the acting head of NPS, the best indicator of problems in terms of service delivery is the rate at which you receive complaints and representations. Now, commercial crime-related representations do come to head office where anybody, any litigant anywhere in South Africa is worried about a CCU matter, which is then brought to the head of NPS to deal with those reps. Almost all of those reps, Chair, of the problem. Most of those representations are dealt with by professional advocates at the head office of the SCCU, and they are referred back to the representative. And I can say with great confidence, Chair, that the rate at which they come back for further review by the NDPP is minimal. If it's not a cause for concern at all. So for me, that is a demonstration that, first of all, the first level of complaint, where the the representation of the complaint came from, was dealt with there. If it is then reviewed by us at head office, goes back and doesn't come back with repercussions, that, Chair, I want to suggest with great respect, that is a demonstration that the people who are dealing with these representations know what they are doing. That is at the level of representations. At the level of conviction rates, Chair, I will ask Ngebe to mention that herself. But the SCCU is a specialist unit with a target rate of convictions standing at 90%. She will tell you where we are currently at the present performance, which is quite satisfactory in our humble view. The vacancy rate at the NDPP has just touched on the vacancy rate now. And I don't want to repeat what the NDPP has said about all the effort we went to in trying to improve the vacancy rate of the NPA broadly and the specialist units in particular. We don't have much cause to complain, if honesty should be the case, Chair. At the occupational category of prosecutors, we have got, out of a staff complement of 229, we have got 35 vacancies, which is at 15% for SCCU prosecutors. And at the admin component, we have got, out of 66 personnel, we've got 14 vacancies, which is at 20%. This is now occupational category prosecutor versus occupational category admin component. So at the level of vacancies, even there I want to confirm with the NTPP that we may complain about many other things, but we cannot complain about a very high vacancy rate. The NTPP has reflected about cases. I want to defer to the NTPP that maybe it may not be very wise of us to go into much detail about cases that are still pending in court. But another extradition that has been mentioned here, which has been finalized now, I think it was mentioned by Honorable. Remind me, sir. Yes, the one of Bushiri, that the Malawi extradition. The Malawi extradition of Bushiri, Chair, was not lost. The Malawi court actually found him extraditable, and he is now taking that decision on review. So it's not a loss. And we all know the circumstances under which he left the country. He actually decanted and left the country whilst on bail, and is currently a fugitive from justice. I think I will pause there, Chair, and leave to my colleague, Nkebe Kanya.
Thank you, Chair. I forgot her name. Not Priestley.
Honorable Neil May.
Neil May.
Neil May, yeah.
Yes. She asked about a few things. One of them was that why do we not work together with the SIU and optimize their resources? We do. We actually do. In a lot of other cases, you'll remember that I spoke a bit. All of us, we all spoke a bit about the COVID-19 cases. Those cases are dealt with in the Fusion Center, which has a number of agencies who are assisting, including the Financial Intelligence Center, the South African Revenue Services. SIU plays a very prominent role there, and they assist. And so it's just one example in that big project. In the other cases, the Tembisa Hospital and the Lottery case, they are assisting with resources. So much so that, in fact, I don't want to speak a lot about these cases that are still in investigation, but what I just want to mention to demonstrate the point I'm making is that the forensic investigation, part of what we were going to outsource to do the money flows. Remember I spoke about the different layers that happens with the different vehicles that are used. Vehicles, I mean, like companies and things and trusts that are used to layer these funds. That money flow part is going to be done by the SIU. So we tap on the resources that they have. So I rest assured that as law enforcement, we are, working together in that regard. But the one thing I also wanted to mention with that is that the SIU primarily collect evidence for civil purposes and asset forfeiture. And so this is why it's required that when we do then give it over to the generals and the DPCI, that we then investigate so that the evidence that we collect meet what is required in the standard for a criminal prosecution. Because with the civil proceedings, you just need to have enough on a balance of probabilities for the court to be convinced to give an order. But when we go to court, it's different. The standard is a bit higher. I think, the conviction rates. In terms of conviction rates, I know that, we get judged by what is the cases that are out there. And the cases are out there in the media because of, whether the profile of the people involved or the impact the matters have. But the everyday cases that we get, and when I say everyday case, I don't mean that it's small cases. The only cases that we do as the SCCU is complex commercial crime. It's complex matters, it's complex corruption, and as I explained, that what is not complex and straightforward will then go to the general prosecution. In that regard, we have maintained a very high conviction rate. The strategic target that we have is 90%. So we aim that of the cases that we take to court, 90% of those we must get a conviction. And because of the methodology that we use, which is that we work together with the police, we investigate, we guide the investigations, we go step by step to review the progress. When you draft the charges, we do that hand in hand. So by the time we take a matter to court, it's ready for court, and I don't want to go into those delays, but it speaks to the method that we use and that it works, because in the past financial years, we're able to meet that. If we don't meet it, it would be by a marginal amount. So for instance, for 2022-2023, our conviction rate was 88% for complex commercial crime. And in that year, we convicted 120 people. We had 120 people, 120 convictions for corruption, complex corruption. In the following year, 2023-2024, our conviction rate was 89.2, which I will round off to 90%, because that's what we do. That's what I was taught in school. You round it off. So it's a 90%, right? And in that year, we had 318 convictions. So you can see the increase that has happened with the previous year, both in conviction rate and with the number of people that we've convicted for corruption. Then in the following year, in 2024-2025, we had an 86% conviction rate, and then for corruption, we then convicted 239. And I can speak to the other stats, but those are available there in the annual reports. But I'm just demonstrating the point that overall, our performance is great in this space. We do get convictions, and unfortunately, it's the few cases that are in the media that we lose, that then perhaps change the narrative as though we're not getting the convictions. Thank you.
Through you, Chair, AFU, Advocate Baji.
Thank you very much for the opportunity, Chair and honourable members. What lessons can be learned to improve case coordination? That was the question from the honourable member, Milmay. So there are a couple of things that has happened at the strategic and operational level. So when the NDPP called me back to rejoin the NPA 5 years ago, there was no special director since I had left. I left over 20 years ago at her level. I was the special director, which is head of operations. And for that long, AFU didn't have a special director. So the NDPP, when she came back first, she found an acting special director, then she had a deputy to double click and focus on AFU. In 2020, our performance was, we obtained 2 out of 11 indicators. Our portfolio committee said this performance is dismal. So I had to submit a report to the portfolio committee, which says, how am I going to improve on the 9 indicators? The Minister of Justice said they want a report on turnaround. I think one of the honourable members spoke about the turnaround. That would include making sure that we recover assets from overseas. So I submitted a turnaround strategy to Justice, which entailed coming up with a directive, as the NDPP explained, that we bring back money from overseas. And as the NDPP has said, we have brought almost 50% of what the criminal asset account had for the last 20 years and within these 4 years. So we had to, strategically, put a lot in place. So collaboration, again, we've got what we call a protocol agreement with our colleagues from SIU. I have signed with my colleague behind me, Advocate Vanara, which is a standard operating procedure. It goes beyond a memorandum of understanding. We'll work together, we'll collaborate. It's about time frames. If they referred lottery cases to AFU to do the freezing orders and the forfeitures, and then turnaround times. Anyway, the High Court, where we take cases, demands turnaround times in terms of civil proceedings and in terms of the law. So then on certain successes for big cases, like taking the Gupta mine back, the Taketa mine, we met weekly with our colleagues in IDEC. We had 2 senior counsel in the matter and a junior. We met weekly, financial investigators, criminal investigators, asset forfeiture unit colleagues. I basically led the team in terms of how we are going to litigate. I took certain decisions around, we're not going to go ex parte, we'll serve our papers on everybody that's affected. So that kind of collaboration where there's a big asset recovery case and get everyone around the room and you meet weekly has worked very well. So we work very closely with IDEC, particularly in big financial investigation, big recoveries overseas, so that when they come to prosecute, we have not in the process revealed far more than we ought to reveal that may prejudice the criminal case much later. So I think the honorable member raised something that will be pleasing to all of us around where does the money go? The money goes to a criminal asset recovery account which is held in Treasury, but it's managed by Justice. There's a committee led by the Minister of Justice in terms of disbursing. As the NTPP explained earlier, 2.2 billion out of that account has gone to fund the police in illegal mining. So, yes, we can make a very successful case for self-funding. In fact, in AFU, we took 10 years data, which is still available, and looked at how much we brought in and how much went into the account after paying for our salaries. And for 10 years, we're able to pay our salaries in AFU and deposit 100 million in criminal asset recovery account. So for 10 years, we demonstrated ability and capacity to run a proper profit and loss. So I think it's one of things that we can look into that would be very useful. So I think there's a lot of operational issues that my colleague Kumam Tenkwana has gotten right in terms of driving the process to deliver, meeting with head office staff, head of legal, and just to make sure that there are protocols, there's guidelines for every for category of cases, because we've done this since 1998. That's when AFU started. So I don't think we can go into those operational issues. But again, as I've said, we've had to work with our colleagues hand in glove, and that's what we have to do as far as the IDEC cases are concerned. And then I've also explained about SIU cases. We have driven this policy around getting the corporates to pay back the money, and we've had these international corporates from Germany. You know about the McKinsey settlement agreement, and it's just because of having to work tightly together. So thank you, Chair. I think I can give that short answer.
Thank you, Chair. Just on one or two questions that haven't been answered. Just broadly on the turnaround strategy of the NPA, Yes, absolutely. You know, when I took office in 2019, we sat down and remember taking office in 2019, the NPA was a captured institution, you know, and we were trying to set about new leadership, trying to get deputies in place, deputy national directors, and capabilities, capacities. There was a lot of work that needed to be done, getting resourcing. So we had a clear, and that was 2019. By the time we got the top leadership in place was 2020. So pretty much nothing happened in that time. It was in the middle of COVID. And then by 2021, when we got out of COVID, when we really could start turning around the institution. And one looks back, it's 4 years ago. And so what we've done in 4 years in terms of turning around the NPA, we have a clear strategy. We've worked on various aspects, from capacitating, from innovation, from, you know, to our in terms of the resourcing, innovating around that. We've also worked together with external partners. We now have what we call not what we call, in terms of Section 38 of the NPA Act, we can get external counsel to assist. We have really exploited that to make sure that where we don't have the necessary skills and capacities, we bring in external counsel. So we had a clear plan to deal with the various aspects of turning around the NPA. And if one looks at our annual reports from then until now, you will see clearly what the NPA has done to actually turn around to being the organization that it is today, notwithstanding the massive challenges that we still face and the system in itself faces. With regard to, I think it was Honorable Maduna mentioned the issue of how did the prosecutor get to be part of Fort Hare case? I dealt with that under the Honorable Trollope's question. You asked about internal controls as well. Just to say that we had an integrity management unit in the NPA for many years that was dealing with aspects relating to prosecutor misconduct, to disciplinary matters, etc. But just last year, we set up the Office for Ethics and Accountability in the NPA in terms of the NPA Act. This office has now been established. It has commenced its work. And so allegations relating to prosecutorial misconduct are forwarded to this part of the NPA to investigate. And then depending on the outcome of that, it then moves into the labor relations processes. But to say that integrity is a huge part of the NPA. We cannot have prosecutors that are not honest, that don't have the highest standards of integrity. So integrity management and ensuring that there's consequence management to prosecutors who do step out of line is a very, very important part. And we've got all of the statistics relating to the disciplinary matters in the NPA. Chair, I am just going through my notes to see if there's anything that we did not deal with. I think we've covered everything, Chair. I'll be guided by you if there's anything that we've omitted. I think it was Honorable Maduna asked about statistics on referrals. If we can get clarity on that, we'd be happy to send it in writing. And also delays, cases, reasons for delaying. We can also look at sending something in writing to the committee. Thank you, Chair.
Thank you very much. I see you picking up your mic, Honorable Beasley.
Yeah, Chair, I asked about the budget and underfunding, and obviously you don't need money then, yeah.
Thank you, Chair. Just to say
what he's asking you is, because he's on the Finance Portfolio Committee, you know.
Yes. No,
so he's saying, how big a check do you want him to write?
I think you should first write one for the Hawks. They help us. We joined at the hip. And if they don't have the skills and capacity, it doesn't help us in the NPA. So I think it's really important. I'm begging the committee to please support the DPCI, because that's our work, you know. And if you know, you could have a prosecutor that's not so good you could have the best prosecutor in a poorly investigated case, you can't do anything. But with a really brilliant investigated case, you know, you can almost be assured of a successful prosecution. So I think, but from our budget, to say that for now, we are good as far as NPA is concerned. But for the outer years, we will definitely, well, for now, we urge that there's no cut in the budget of the NPA, but for the outer years, and also we are building into our budget, one of the important issues for the NPA, which perhaps will be useful for the committee to also take note of, is the operational and financial independence of the NPA, which the minister has publicly also supported and also indicated her support for this to me. It's really important that this aspect moves speedily forward. It would require legislative amendment because currently the DG of Justice is the accounting officer of the NPA. The NPA is the only entity in the crime-fighting family that does not have its own accounting officer. All of the others, like the SIU, the DPCI, SARS, all have that, but not the NPA. And it really affects the efficiency, operational efficiency of the NPA. This has been a matter that's been long been on the cards. So hopefully that is something, that is one of the challenges that we would actually also mention in terms of how to increase efficiency. So the budget certainly in the outer years we will need, because it's also, we've built into that the move, with regard to the operational and financial independence of the NPA. Thank you, Chair.
Thank you. So I would like to give you, the problem is we going to get down to an hour dealing with the same first round of questions, and I am concerned that will be here until 7 o'clock. Honorable Skosana, so I had started that side. You were not in the room. So let me ask if you want to get in the ring or not.
No, I'm fine, Chair, because I may end up repeating questions that were asked when I was not here.
No, you were well represented by Honorable Matuna there.
Thank you from that side. I'm worried.
I hope I'll get time to ask questions. So, Honorable Isaac just left now. So, Honorable Matiwane and Honorable Isaac is coming back. So, but let's move along. Honorable Matiwane, then Honorable Ment.
Thank you, Chairperson. The problems of the NPA started with the Prima Facie case. I think that was in 2003. And I don't think it ever recovered from that. So, what I want to check, Chair, I think the NDPP was scathing on the Special Investigating Unit. When she says, the SIU presentation says that their evidence meets the standard of criminal prosecution. And then the NDPP says, no, it does not meet the standard for criminal prosecution. So we would need clarity from that, because I think that the operational challenges that they speak about, even calling for the amendment of the SIU Act, might emanate from that. Because I think in the Act, the SIU was envisaged to be capable of investigating and of collecting evidence. However, it's like we're dealing with an onion here today, because we came for a briefing for SIU referrals, but we end up going deeper into the operational matters of the three institutions. So I want to hear from the NDPP if she can clarify us on this, if she doesn't regard the investigations that come from the SIU as being complete. Hence, she's saying that they should be referred to an investigative unit. However, the SIU Act says that they are supposed to investigate, collect evidence, institute civil claims, and then refer for prosecution. The prosecutor is saying, no, they must go back to investigation stage. So we just need clarity around those issues. And then there are so many issues that were said. I think that's the one thing I enjoy about these long meetings, is because so much information gets to be shared, even if it's sound bites. But people get to share a lot of information, maybe. that might be beneficial to us in the future. So the NDPP has been on the media speaking about infiltration within the NPA. And then she says that there are people within the NPA, if I'm quoting her, I'm subject to correction, that there are people in the NPA who are not individuals who do not want to uphold the rule of law. And she says that when she came in 2019, the NPA was captured, which is, it would be debatable if you even look at the standard of evidence that was produced at the Zondo Commission. Some of the things that were said there were fairy tales, sorry to say that. But some fairy tales were played out in the Zondo Commission. Maybe that's one of the reasons why it is so difficult for the NPA to get convictions from referrals from the Zondo Commission, because of the standard of evidence and the quality of the quality and the standard of the evidence that was used in the Zondo Commission. Like I said, there are so many issues that were mentioned about the Gupta extradition. NPA saying they followed everything. The UAE saying that South Africa had missing documentation that were not submitted. I think that has been covered. And then on the provincial DPPs, you've touched on this. This emanates from the question from Honorable Trollip. You said that when you found out, you removed the prosecutor, which is a reactive exercise instead of being a proactive exercise. So I just want to check, is there a challenge with the provincial DPPs where they might be able to take decisions that might compromise the integrity of the institution that you lead without your knowledge, and you only have to come in to do damage control? And then also looking at the reasons not to prosecute, I think it's about close to 90% of the cases of the referrals from the SIU, reason not to prosecute or insufficient evidence. Can you just clarify us more on that 90%? What is happening there? What are these defaults that we are finding with the quality of investigations or referrals that you are getting from the SIU? Thank you. Oh, final one on the asset forfeiture unit. I just need clarity. I think for public interest, because there is a perception that there are angels and devils in South Africa when it comes to the issue of state capture. And here you have the SEP contract, the ABB impulse contracts, which are currently under investigation, but you have a restitution and a punitive reparations. So perhaps you can just clarify for me the difference between the restitution and punitive reparations and the preservation order that others are under. Thank you.
Thank you. Honorable Member.
Thank you very much, Chair. The first thing I want to check with the NDPP is the guidelines that they provide to the other units in terms of assisting them. This is in relation to the statement the NDPP just made, that you may have the best prosecutor and have a weekly investigated case, and the two don't give you a success in terms of prosecution. What are the guidelines that are there? You may not go into them into detail, but at what point do you converge and make sure, in particular, these corruption cases? Because today, as much as now we're dealing with everything else, We're here to make sure that the corruption cases are put to rest. People are in jail for stealing from the people. Because I am not getting a sense that prioritization is given to corruption cases. And I'm not getting a sense that there is synchronization amongst the law enforcement agencies. Then we have an issue of court cases that take forever. But that also is influenced by how long the other processes are taking place. I'll make a case in point. I closed my laptop now. There's a case of 2012 amongst the cases there. Then a proclamation would have taken place maybe 3 years later. And then after the proclamation, that will take another 2-3 years. Then it's sent to you. You still send it to DPCI and then. But for someone who's seeing a case of 2012 with is worth above $500 million, $500 million, is looking at it and say, but there's no hope. Because there ought to be a place where there is synchrony in terms of the prioritization and the aim of making sure we are ridding this country of corruption and ensuring that we have successful prosecution. And it lies with the National Prosecuting Authority to make sure that we don't take cases which are not going to get us anywhere to court, as much as all the other agencies would have pushed the docket through. But when it reaches that point, at what point do you say, this is not going to be successful, but there is a loss? And you made another statement to say you are for the poor. There's a loss to the poor, but the action doesn't talk to the loss to the poor. The agency doesn't talk to the loss to the poor. So at what point do we converge and make sure that things are done properly? I'm also interested into, as much as the IDEC was established last year, where are we with it in terms of isolating these corruption cases to a point where the portfolio committee on justice is also advocating for the agency in moving for judges and magistrates who will predominantly look into these cases of corruption and precisely make sure that there is movement. Because if we don't have a strong IDEC, then we don't have cases that are piling up, which are putting pressure into the system for the system to establish more courts and employ, or rather promote, more judges, magistrates to ensure that these cases are dealt with. Now, there is another, I would say, I'll put it this way, that justice in South Africa is very expensive for someone who doesn't have anything. And there's been now a lot of Section 174s in courts where prosecutors are found wanting and they can't prove their cases against accused. Then magistrates have to tell the prosecution that there's nothing here. You are arguing absolutely nothing. This person must walk. What do you do in that case as an NDPP? Because here you are sitting with a prosecutor who's wasting time on something that is not there. Meantime, the court roll is piling up, and a person keeps postponing a case that is not there, to a point where then the accused apply, and the court agrees that, yeah, there's nothing here. What happens to such prosecutors? Because at the end of the day, those are the civil claims that come to the state. And there's nothing that we are hearing in terms of the accountability on the weak prosecution. This also links to, I think my colleague partially asked this question. I would disagree with you if you say the DPP of Eastern Cape acted recklessly by appointing that prosecutor into another case, because there is nothing that said this particular prosecutor must not be given work of any kind. How do you say that? The moment you have a case or a transgression against a prosecutor, there must have been some sort of suspension of that particular person, but the person is here, is on the payroll, is reporting on duty every day. How do you expect me to sit with a person who's not going to get a job when we have cases piling up? Cases are here piling up. We have a person who's walking in the door every day. We're expected not to touch that person, yet the person is not on suspension. There was no message. Your messages are against each other. Don't use them, yet the person is here. What is the message that you want to send? Are you suspending the person, removing them from the system so that they are not of use, as well as they are also not intervening with whoever is investigating them at that workplace? So I'll disagree with you if ever you had maybe charged the DPP of the Eastern Cape or reprimanded them, because you didn't do what you were supposed to do of removing the person. Now, this also links to what we were talking about earlier on of Umutoso versus Guptas and versus Bushiri. We may be saying these are still ongoing, but the fact is that it's unlikely that Umutoso will ever come back to this country, because we released him to get out of the country. We're not getting Bushiri. Bushiri now is reviewing his own country's outcomes. In his country, we can't touch him. We allow Umutoso to get out even when you are saying you are appealing the decision of a judge. But then he's out of here with all the crimes that he has committed, serious crimes and the violation of its young children. It's not even women. It's young children that he violated. Yet we'll sit here and be like, no, we will go to Nigeria, we'll talk to Nigeria, maybe will listen to us, unlike the Arab Emirates. We don't know that. We have no control over what Nigeria will say, will do, and what it can decide in terms of this person. And this is all happening because the National Prosecuting Authority, again, is in the middle of these cases that do not find successors. So I'm not sure what would be the best way to deal with. The NDPP should tell us, what is it that must be done in this country? Is it training that is lacking? Are these people doing their job or not doing their job? What are the assessments that are there that you carry out throughout? I'm sure there is yearly assessments for everyone. What are the assessments? Are your assessments telling you that these are the people who are fit and proper to prosecute over cases that are serious and ensure that we get successful prosecution out of that? Now, here is another observation which is very problematic for me. And earlier on, again, in DPP, you say there is no executive who has ever come to you to interfere in any way possible. I'm not going to say you You are not correct. But here is what my observation. Both DPCI and yourselves, the way you move is very coincidental with political events. I'll give you an example of many cases. In the Eastern Cape, which is a den of thieves, corruption of the Eastern Cape is out of this world. There was once a funeral of the late Tata Mandela, and then people embezzled funds, corrupted and everything. To this day, we're seeing people, when there is a political event in the Eastern Cape, which is aligned with leadership and anything, then we're going to see the Hawks arresting people. And then after, once conferences are over and everything, then no one is being arrested. Same applies to how the cases and people are charged at the NPA. I'll make an example with one case now. The case of Ace Magashule. He was charged and then he was on a step aside. He's being prosecuted. Time and again, the case is postponed as if something is happening, but something is not happening. Because if you listen to the reasons of postponement of that case, which is not reaching its finality, again is National Prosecuting Authority. So the problem is that you also made that statement just recently, I think about 2 weeks ago, that there are elements of interference within the NPA and there is political interference in the NPA. So if that statement is not true, or which you made, and today you say there's no one who has ever interfered, why did you say that? And why are the events that have been taking place very coincidentally aligned with political events? The last one, Chair, is the witness protection. And unfortunately, I'm going to go back to the case of the late Comrade Cindy Somakak. May his soul rest in peace. There was once a witness, I think in our second parliament, who was on radio saying, I can't go home. I'm a witness to Makaka's case and the NPA has failed to protect me. This person was talking on radio. And my colleague, Maduna, also mentioned that there's been other people who died. It's not like people don't know of these corrupt elements and who are behind them, but there is a lack or none. There's zero protection of witnesses in South Africa. And it only takes the SIU proclamation to look into the cases when people could have laid cases way before the proclamations are signed. And even these proclamations are as a result, most of them, of people calling the SIU anonymously to say, look into these particular transactions that are taking place in these areas. I don't want to be known. Just go there and look into it. Imagine if people were not scared of saying things that are happening as they are, knowing that will be protected. We wouldn't be where we are today. What is the state of witness protection? And how can people come out safely and say, here is corruption taking place? We were just now in OR Tambo to see Etsonyeni Dam. A lot of money has been spent already. But there's just a wall. Even yourself, if you go there, you will be ashamed. There's just a wall and some few bags of cement that's laying there. But there's no accountability as to who is responsible for that. But people do know, in particular service providers. Service providers in the Eastern Cape tell you, we would like to say that politician A, official B, official C have been telling me if I'm going to give them 10%, I will get this gig. I did receive a tender and I invoiced once. 90% of it was taken by officials and politicians. That is why I left the site. That's why I can't go back to the site. I don't want to be involved in the Eastern Cape tenders anymore. But those people don't want to come up front and say those things. They don't want to refuse with that money because they're going to end up dead. And there's no protection for them. Now, I want to understand, how do we get this right? Because for as long as witness protection is not there, corruption is going to thrive. Thank you, Chair.
Thank you very much. Honorable Isak, do you have a question? Because it's curtains from now on. Thank you. Sorry, Honorable Kubega.
Chair, just I know it's not. It's got nothing to do with this, but I think recently here in Parliament we've had an issue of Honorable Sithole from the IFP who was gunned down in Johannesburg. Chair, we need to look at that thing. I'm not a member of the IFP, but if in this country we're going to have a situation where members of Parliament of the National Assembly are going to be gunned down in the streets like dogs, that means we are following. We will be next, and I can show you, we will definitely be next if that thing is left unchecked. I don't know, Chair, maybe
you make a good point. Thank you. And we've got the Hawks here.
Yes, that's why I'm mentioning it. Thank you, Chair.
Thank you.
Sorry, Chair. I left out the case of SAA and SA Express, the IDEC people. If we can get the SAA and the SA Express progress report, because there is a mention of it's a complex matter. We nearly lost SAA to people who wanted to buy it in some shady deal, which fortunately was shut down by Parliament. But you are writing here, it's complex. And can we get that progress report as well? Thanks.
Chair, okay, so let's, there's quite a few questions. I'm just trying to, maybe I'll just hand over to colleagues to deal with questions that relate to the units, and then I'll come back and deal with what's remaining. So, Advocate Mziniati and Nkebe Kanyane. I think Honourable Mente asked questions about guidelines and prosecutor. Yeah, thank you, Chair. Through you, Chair.
Thank you, Chair. Yeah, if I can start maybe with the question of the NTPP did mention, and I think this is going to go back to the questions by Honourable Member Mende and Matiwan about this case of Forte. I think the NTPP did allude to the fact there that you know the matter is receiving attention. It's actually allocated to myself to look into it. So the extent of the investigations, honourable members, maybe I may not want to divulge the details. As to the reasons why, honourable members, the prosecutor remained there after the issues came to the attention of the NTPP, I think that is an aspect that we will, after engaging with the personnel there, advise the NTPP upon. I think I can leave it that one at that. If I can kindly request members to allow that, maybe in a later feedback to SCOPA, we can update. But it is a matter that is currently receiving attention. As soon as this week, actually, we are engaging the team down there. I don't want to repeat the issues.
Sorry, can I say once that's done, so the Secretariat will just stay in touch with you. You can make a written submission, so you don't need to wait until we see each other again.
Okay.
But the Secretariat will be in touch with the NDPP's office.
Okay. No, thank you, Chair. The issues about extraditions and Chair have been traversed by the NDPP. The only thing that I may want to emphasize, in as much as, and the NDPP touched on this, but because it is fresh again from Member Mente and Member Matiwan, generally, and it's the issue of the UAE is very disappointing to all of us in the NPA. Broadly, we do succeed on extraditions. I mean, there are 2 now in the UK that are on appeal. They were successful, but these people are always appealing, So it is not something that is going to happen overnight, and it is a lengthy process, but I think comfort should be derived from the fact that it is a system of the legal jurisprudence applicable to international communities that we tap on. We've got treaties, countries do demonstrate goodwill, and when the circumstances permit, they find the fugitives extraditable, and the fugitives just simply continue to fight. I think maybe the other issues about witness protection and the questions that Honorable Mender asked about accountability that the NDPP may want to exercise over her subordinates, I will leave those to her. Thank you, Chair.
Chair, if I could just guide colleagues, you could also, through you, Chair, deal with the allegation of a lot of Section 174 discharges, and if we have any response to that. Thank you, Chair.
Oh, yeah, there was that question. Thank you, NDPP. I'll be honest with the honourable member Mente about that. I have not. I didn't investigate that before coming here. But 174 we all know is a legal process of the NPA Act. But I would like to suggest, Chair, with due respect, maybe Member Mente can give us details, but we don't get most of these cases discharged at end of state case. We are not getting any alarming signals that we are losing cases, because your 174 acquittal actually is a very, very borderline case. You may want to wonder why it was enrolled.
May I ask that we, for the public, just simplify what a 174 discharge is? That when the prosecutors have presented their case and the defense makes an application to dismiss without having to present their own case? Is that it?
Yes.
That is it. Okay, yeah. No, I like to just
make
sure we all know what we're talking about.
Yes,
okay.
Yes. Member Mente knows about it very well. I'm joking. But it is that section, true, Chair, of the 17 of the Criminal Procedure Act, where the state leads all its evidence by state witnesses, and then the prosecutor says, I close the case with the state. And then the accused or his attorney says to the court, I apply for this accused to be discharged because none of this evidence brings a case for him to answer. And then the magistrate uses his own analysis. There are principles that apply, and then the magistrate, if he agrees with the accused, then acquits. And then it is, of course, a process that the NPA, if it feels aggrieved, can take it further. And the example is the one that is still fresh in our mind. The Nulane case, where all those accused were acquitted on 174, and there was a successful appeal. Thank you.
NDPP, not a lot. Perhaps I could just speak to the last issue regarding the 174 discharge. I also am not certain what informs that we've got a lot of Section 174. I don't know, and also I'm not certain whether it's what numbers were looked at to come to that conclusion, and whether are we talking about generally in the NPA, the 174s generally, or are we talking in this space that we're talking about now, complex corruption or commercial crime. So I'm not certain, but what I can say is that
could it help if you attempt to do what I asked last time? I can't remember what it was in relation to where I say on average. Do these things succeed or not? Because I think what becomes difficult for the public is that you get a high-profile case, and in that high-profile case, the Section 174 is successful, or there is an acquittal at the end, and the judge criticizes the NPA's management of the case itself. And those things create the impression, and I think would be justified as a public to say, but these guys don't know what they're doing.
Yes, I understand that, but then it would be reckless of me to say, we don't get a lot of on Section 74 when I'm not looking at anything, or give you an average. It would be very reckless of me to do that. But that's why I wanted to get clarity to say, are we talking about, on what basis is this statement made? Is it that we looked at, we don't usually report on this in the annual report, right? But I have received confirmation from our ops team that we do keep stats on, we separate them. So we have stats on Section 174s and not guilty, where the entire case happened. So I should be able next time to then give you an average, Chair, to say, and answer the member to say, stand boldly and say our 174 Section 174 acquittals are very low, comparatively speaking, to the number of prosecutions we take. I want to be able to do that, but I can't do that without any figures in front of me. So, but I take comfort that we do make a distinction, because I was worried that because both a not guilty at the end of the trial and a 174 is the same thing, in the sense that the accused was found not guilty. So I was worried that perhaps we're lumping them together. But I have confirmation now that we do, when we keep our stats, separate them on the ICMS and the ECMS, that we can be able to give that report to, so then I can stand up and say, well, we do have a lot of 174s, or we don't have a lot of 174s. At the moment, I cannot make that statement, and so either.
No, don't worry about it. Let's put it. So what Advocate Mzinyati with the Secretary is going to send in that same correspondence, just provide us with the stats.
Yes, I just want to speak, and I don't know if I'll be speaking out of 10 NDPP, but with regards to witness protection, right? It's understandable that in certain cases, witnesses are afraid to come to the fore and give evidence and cooperate. But when people do come in, and also the witnesses are reluctant to take up the offer of witness protection. But what I can say confidently here is that when they do take up the offer of witness protection, we have a good record, and perhaps then people can speak to that. We've got a good record in terms of witnesses who were harmed once in the program. But because it's an invasive process, you have to give up a lot of yourself and your family to be able to go into the program. A lot of witnesses are reluctant to take up the offer, but when they do take up the offer, we have a good record in terms of protecting witnesses that are in witness protection. Thank you.
Now that you're saying it, was that offer given to the witnesses in the Umutoso case? Because I know the last witness was gunned down in PE, she was a witness, and other witnesses were also eliminated in the Omotosa case. That's one, but there's the rest of them. So at what point do you offer this witness protection and protect witnesses successfully?
I won't be able to speak to the Omotosa case. It's outside my thing. But what I can speak to, and what I'm speaking to, is that once they come in, there aren't incidents. I can't speak to the Omotosa because it's not within my space. I don't know whether it was offered or not. Maybe the DNDP or the NPP can speak to that. But I know that from the police, from the NPA, it's something that if we are aware that witnesses are at risk, or when risks, when they assess a case, that is offered. But I can't speak about this matter. I have no knowledge thereof. Thank you.
Don't think there were any AFU matters, or were they? Yeah, please go ahead. Chair, through you.
Just a quick one. There was a question around the good and the bad regarding the SAP and ABB, punitive reparation. Is this, restoration, restitution? What does all this mean, and what is preservation? So, with all the corporate alternative dispute resolution that we've entered to, this is restitution. It's supported by UNCAC, international obligation that we should be able to enter into these mechanisms, and UNODC and so basically it's all about making good that you unduly benefited. So so punitive reparation then becomes a fine that SAP, ABB, McKinsey pays into this criminal asset recovery account. It's a fine. We call it punitive reparation. Over and above that, they make good to the victim or the SOE. So in ABB, money was paid back to ESCOM. In SAP, it was paid back to ESCOM Transnet, PRASA, City of Johannesburg. There was a lot of institution where disgorgement, the contract amount was paid back to those institutions. Then the other question quickly was, what is preservation? Preservation is similar to restraint. It's a freezing order. And preservation is non-conviction based. So we're not going to wait for the case to be, prosecuted and there's a conviction. We're going to apply for the money to be forfeited to the state, the assets to be forfeited to the state within 90 days. Hope I've captured the question correctly.
Chair, the questions...
Sorry, just quickly, there's a clarity-seeking question.
No, just one follow-up on that issue. So the matters of APP, SEP, they are currently under investigation, right? So
that is correct.
And then you enter into a dispute resolution to say this is the amount of money that we are going to pay.
That's correct.
And then that amount of money that they are going to pay, the scale of the graft or the corruption that they are accused of as compared to the money that they are paying, does that balance out? Maybe once the criminal prosecution is finalized, you'd find that it was at a massive scale and you maybe only charge them 0.5 or 1% of what they took from the fiscus.
So it's the contract amount gets paid back. The entire contract amount gets paid back. So in the case of ESCOM, SAP paid back 500 million back to ESCOM 344 million to the Department of Water and Sanitation, I think another 321 million back to Transnet. The entire amount of the contract is paid back, where there was additional bribes paid. So money wasn't, all these SOEs had paid, right, SAP for services, for their software. But in the process, there were people who got kickbacks on the side. So we are saying these contracts are tainted. So the entire amount gets refunded back to the institution. But over and above that, 750 million got paid. In addition to this disgorgement, it got paid into the criminal asset recovery account. That's why we call it punitive reparation. It's a fine. So the wrongdoers, the individuals, all the people who, because it's not the company that's committed the crime, it's the people in the company who were paying bribes out there. Those ones are still going to be prosecuted. The investigations are ongoing.
Okay, let me try and assist here because this was explained. So I'm going to try and just simplify it because we might be here a long time. So what I understood earlier on, you were saying, is that in these cases, there are natural persons and there are companies. The company earns the profit from the proceeds of the corruption. The individuals do the wrongdoing. They pay the bribes and so on. Because you cannot put a company in prison, you then say, you as the company, every cent that you got from this contract, you must pay back to this institution, number one. Number two, you need to pay an additional amount of money as punishment for your employees engaging in criminal activity in this way. That's a second thing. So that's what you as a corporate are doing. Further, we require you to cooperate with us as the investigators and prosecutors by providing all information that we need in order to convict your employees and their accomplices. And therefore, in that case, the money comes in, but the prosecution against the individuals continues. But the company itself, the board of the company, has said, sorry, we've done wrong. An example in the state capture inquiry would be EOH, where there was new management and a new board, and they said the company did wrong, we will pay the money back, and we will then cooperate in the process. Is that the case that we're talking about here? Is this helpful? By way of explanation, I'm not saying whether it's right or wrong. I am just saying by way of providing clarity. Does it help?
No, it helps. I was playing devil's advocate because there is that principle of piercing the corporate veil in company law. There are certain companies that are besmirched who were involved in state capture. And there are certain companies who come off light where you say, no, the problem is employees, not the ones who have a fiduciary duty, which is the directors. In some instances, you go after the directors, but with multinational companies, you go for the employees, like your foot soldiers. So I just wanted to hear the side of the NPA on that.
Okay, I think there's an answer. So you've asked the question more directly. Thank you. So I think there's an answer coming. Please, can we keep them concise?
The entity pays. Directors, shareholders, and employees remain criminally liable and culpable and prosecutable if there is evidence to prove the criminality, and they then go to court. It's only the entity. It does not absolve shareholders, directors, etc. So it's not just employees, to be clear, Chair. Thank you.
And to add to that, Chair, as the NPA, we want to hold those most responsible accountable. Our approach is we shouldn't go for the foot soldiers. We must go for the ones at the top, the kingpins, the directors, the ones that benefited the most. That is our approach. Very often in these matters, you have to go for the lower end, because in order to build up to that, you need insiders. And sometimes you need to arrest the insiders to be able to get people to testify. And so you go up the chain. But ultimately, we want to ensure that those most responsible are held accountable. And I'll just deal with a couple of other issues quickly. On the issue of the infiltration of the NPA, I did make that comment, and I did correct it immediately the next morning to say that it's not infiltration, and I did say that perhaps there are people within the NPA that are not aligned to the vision of the leadership in terms of upholding the rule of law. So I clarified that. And then you asked the question about, I think it was, whether there were two, political interference. I think this was Honorable Mente who asked about political interference in the NPA. So I never said that there was political interference in the NPA. In fact, I was very clear, like I said today, that there has not been any political interference in the NPA. But of course, that is at the level that what I understand, but I cannot say for sure that there aren't people in the NPA that might be influenced. But as far as I'm concerned, there's been absolutely no political interference. So I want to clarify that. With regard to the issue of clarity on the standard, this was Honorable Matiwane. I wasn't scathing on the SIU. It was, in fact, Advocate Motibi himself who said that he needs to correct the slide. And our colleagues from DPCI also mentioned that once the SIU, I want to emphasize, does such incredibly good work in terms of their mandate and does a lot of the groundwork. And, that really helps in terms of building a case to get to the standard that would meet the standard for prosecutions. But what they do is hugely important in terms of, we're not starting at ground zero. There's a lot of lead information and other evidence that can be used. So I want to clarify that. Is there a challenge with DPPs if the NDPP only comes in? To be clear, the DPPs are very powerful individuals in the National Prosecuting Authority, the heads of the provinces. They, in fact, are the ones that have control over the provinces in the sense that they manage it. You are the leader in the province. And in terms of the NPA Act, as I think I explained earlier, they have the authority to decide on prosecution of cases, except in a very few cases where the National Director does, like racketeering, like terrorism cases, terror financing. Those cases come up to the NDPP. But the DPPs are the ones that they run the provinces. And of course, they are very senior members of the NPA. And as a National Director, I must defer to them to know that they are managing their provinces well, that they are doing what they need to do, and they're ensuring that they have the right prosecutors, that the cases they're doing the necessary risk assessments, and that they are managing cases properly. Of course, now at the head office, what we do have is that we have identified high-profile cases, and DPPs are required to send up to the national office this very risk assessment. What are they doing to ensure that they identify the risk properly, whatever it might be, whether it's capacity, you need more prosecutors, whether it's, witness risks, whatever they are, identify it, what are your mitigating factors, and that all now with high-profile matters comes up to the national office so that we don't get embarrassed by high-profile cases that actually don't succeed in court. But, of course, if a DPP doesn't bring anything to the notice of the National Director, the NDPP will only become aware when things go wrong. And then, of course, it will be about damage control, but we're trying to minimize that to ensure that we've put in this risk mitigation plan in place. Prioritization, Honorable Mentor, is addressing corruption has been a top priority for the NPA from day one. And I'll be very candid with you. When I took office in 2019, I knew there were serious challenges in the NPA, in the system, but I didn't think it will be this difficult to prosecute corruption cases. We know that globally, corruption-related investigations take years. If one looks at the Steinhoff case, which was also being investigated by the German authorities that are much more well-resourced than us in South Africa, also coming out into working in a very fiscally constrained environment. They indicted 1 year before we did, in that particular matter. So it shows that we did in 6 years, they did in 5 years. So corruption cases, for various reasons that colleagues have said here, whether it's mutual legal assistance matters, whether it's the layering, the complexity of it, and the fact that we as well as prosecutors, when we fail, we want to make sure that cases are as watertight as possible when we go to court with them. And so we've got to make sure that we tick all the boxes, because the risk of failing in a prosecution, we all know how high it is. There's barely 10 cases that has almost destroyed the NPA's reputation. So we really want to make sure that when we take these cases to court, we are as trial ready as possible. We've checked and rechecked and made sure that the evidence meets the standard. And that takes time. And it takes even more time when you're dealing in a situation like the IDAC and the DPCI, where they are not properly resourced, where you're still getting to the point where you're getting capabilities, capacities. But I'm certainly hoping that now, with the IDAC being permanent, with us having the digital evidence unit that has been established, that we will see these cases moving quicker. Because as much as you feel that the face of corruption in this country are the people that don't have sanitation, housing, the basic infrastructure. And that is what we in the NPA want to make sure, that those responsible for that have stolen from our people, must be held accountable. And whatever the outcomes are, whether it's orange overalls, we want to do our best to ensure that there's justice and accountability. So that has always been a very, very high profile prioritization issue for us. Claims that mount against the state, we have a legal affairs division in the NPA that deals with claims against the state. We can give you statistics on that, but even 5% perhaps is too much. But if I recall correctly, Advocate Srabaji, we lose about 5% of cases where claims are brought against the prosecuting authority. And when that happens, we ensure that there is consequence management. Immediately, the Legal Affairs Division would report it to the NPS to say, in this particular case, we lost a matter. This is what happened. And they will ensure they look into the prosecutor's conduct to see, why did we lose that? For the prosecutor concerned, what do we need to do in terms of consequence management, whether it's training, whatever, disciplinary processes, if it's recklessness, and also to look at what lessons can we learn to share with other divisions to make sure that these things do not happen. And I agree with you on the issue of the prosecutor that was found to have compromised, allegations of misconduct in the Omatozo matter. And you say you can't have a prosecutor in an office doing nothing. I think the concerns that were raised is that this particular prosecutor was given another extremely high-profile matter, and that was the question that was raised. It wasn't that the prosecutor should be sitting around doing nothing, because we, of course, have a lot of work. So I completely agree with you on that point. On witness protection, yes, so we have a witness protection unit in the NPA, and I think we must make a distinction between witness protection and whistleblower protection. And when it comes to, and in the Omatozo matter, we can give you a written report on the issue of witness protection, because I know that matter was raised before, and we can give you details about what happened in that particular matter. With regard to the, once witnesses the risk is assessed, and once they enter the witness protection program, then, as Advocate Nkebe said, there's been no harm to any witness on the program. But there is a process to assess the risk, and then to bring in witnesses into the program. And as Advocate Nkwebe also said, this is not an easy decision for witnesses to make to come into a program, because sometimes it's not just the witness, it's also the families, etc. So there are various reasons why people may not be in protection, but it would be very useful if we get particular cases and then we can explain what happened in a particular case, why the person wasn't admitted to the program, and that kind of detail. But whistleblower protection is a bigger question in our issue in our country. And I know that the Department of Justice is working on this issue and potentially amendments to the Witness Protection Act to introduce the issue of whistleblower protection. But at the moment, this is a gap in our country, that you can only get into the witness protection program when you're a witness. But if you're a whistleblower, there's a huge gap. And that is a matter that the department is currently addressing. Chair, I hope we've addressed all the issues that have been raised, Chair.
Or the assessment of prosecutors.
Sorry, Chair, I'm just trying to check in what context. Maybe the Honourable colleague could just clarify that question for us.
Sure. No, Honourable Member can help.
Now, NDPP, in a moment, there is continuous assessment of workers, and you check if they still fit and proper to carry out the duties. Do you have a particular assessment for your prosecutors? And do you then deal with this in relation to the cases they carry in court? Because one is the area of where people afford. Hence, I said justice in South Africa is very expensive. If you afford, then you get a lawyer which is going to go to court and argue a section 174 for you. But there's a person who can't, even though they are standing there with a case that is not a case. Number two, the number of postponements that are done by the NPA should be an indicator as to why are you postponing as a prosecutor your case. Then there would be a variety of reasons of that. But where NPA is concerned, there should never be a postponement which is of a reason from the NPA side. Thank you.
Thank you, Chair. Just on the postponements, maybe, and Mzanyati and Advocate Nkwebe, I think you touched on that. Can I hand over to you and then?
Thank you.
Thank you, Chair. Thank you, Chair, through you.
Thank you, NTPP. It is correct, Chair and members. We define backlogs. There is a definition that has been adopted that says, in the district court, a case becomes a backlog after it has not been finalized 6 months after its first enrollment. In the regional court, if a case has not been finalized 9 months after first appearance, it becomes a backlog, and in the High Court, that period becomes a year. Now, we monitor backlogs. So I think this is the second layer of Honourable Member Mente's issue, but I want to start with it because it talks about that lag time or the time that a case becomes a backlog. And we are even, as an organization, taken to task, apart from taking ourselves to task about monitoring backlogs, but even in the cluster itself, the issue of backlogs is a serious concern. They are being monitored even at the PEECs, which are the judiciary-led structures of efficiency enhancement. So to that extent, Honourable Member, we monitor backlogs and we want to keep them at a minimum. Then in terms of performance management, every prosecutor, in fact every official in the NPA, signs a performance agreement at the beginning of every financial year. And as Honourable Member mentions, there are indicators in every performance agreement that get monitored on a quarterly basis by supervisors. We also do follow that, and I'm sure supervisors, because people manage various sections. An admin person looks at different things from a prosecutorial manager. So I do want to say, working in the NPS myself, honorable member, that a prosecutor who wins, who loses cases as a matter of routine, surely must attract the attention of his supervisor and attract consequence management. I don't want to put it stronger than that, but at least it is monitored, honorable member.
All right, honorable members, thank you very much. I'm going to just give some direction in terms of what we're going to do. So sorry.
Sorry, I apologize to do that.
No, please go ahead.
But I believe we have a duty to place our version on the record. It's important. Regarding this, I think it's called the criminal standard here. When I presented, I said we probably need to reword that. And I said it in line with our what our legislation says. Our legislation says we need to refer evidence regarding or which points to the commission of an offense to the relevant prosecuting authority. It doesn't mention the evidence that meets the criminal standard and so on, but I think that's really the way of talking, This is what the legislation says. Now, when it comes to the mandate, right? When it comes to the mandate, whether we've got a mandate to investigate a crime called corruption, our view, we've stated it in Scopa several times, that we believe we've got the mandate not to prosecute, the mandate to investigate corruption. And why do we say that? Without taking a lot of time, Chair, Section 2, subsection 2 of our legislation says the President may exercise powers under subsection 1. Subsection 1 deals with where he signs the proclamation and so on, right? On the grounds of any of the alleged, that's A, B, C, D, F says, on the grounds of any alleged offense referred to in Part 1 to 4, or Section 17, 20, 21, and Chapter 2 of the Prevention and Combating of Corrupt Activities Act, right? And which offenses were committed in connection with the affairs of the state institution, because we do investigate in the state institutions. So this is where we get our mandate, right? So, and we've been investigating corruption since the SIU was formed. I don't recall that there has ever been any legal challenge where any of those we investigate ever challenged this part. Now, Chair, as to put these provisions to practice, for us to be able to know that the evidence points to an offense, is that we should be knowledgeable on what an offense is, right? And I've said it before that most of the SIU colleagues, in fact, come from DSO, they are the police, and most of them are attorneys, and they're well trained in criminal law. Well, if I have to say so myself, I was a prosecutor before. And since I left the criminal courts, I don't think the criminal law has changed that much, in terms of the offenses that we need to investigate. So we are able to know when evidence points to the elements of a crime. Then at that point, we say, here's the evidence. From our point of view, that points prima facie to a crime. And then the NPA takes over. Then they decide as best they can. And that's where we are saying now that for this on forwarding to DPCI, it's an issue that really requires, sort of correction, because it's a systemic issue. Because as we speak, we believe in terms of the mandate, we have the mandate to investigate. And Chair, just to indicate that because we do refer, the legislation says relevant prosecuting authorities, right? In the majority, we refer to NDPP. But in some instances, of course, we copy the DPPs, right? Is it DPP in the provinces? There are cases, my colleagues have indicated to me, and Mr. Nakhetwa is sitting there, is able to just say which provinces are those. In some provinces, there are provinces which were able to take the evidence that we gave them to court and they got convictions. So I think there's an opportunity here to sort of engage and say, really, how do we resolve? I recall speaking to the NDPP not so long after she arrived. I said, perhaps we need a test case here. Perhaps we need a test case to say, will the court reject this evidence or not? So we've never reached that stage. But, Chair, we will not belabor the committee with that. But I think I was enjoined really to put our version on record so that the committee is clarified. Thank you.
No, thank you very much. So, thank you for that, Advocate Matibi. So, in my closing, I was actually going to say what we're going to do next is to have the ministers of police and the ministers of justice. We will, in the investigation, ask them to invite you to come along. Not so big teams, because we're going to deal with matters of legislation, resourcing, and policy, right? The reason I also want us to have you here is that there are questions which I wanted to ask around the use of PRECA, for instance, just as a matter of philosophy at the NPA and the SIU in terms of how it understands what the referral should say itself to the DPCI, and whether the hawks themselves take that into account. That's a sort of an almost legal philosophical discussion, but it's very, very important that I will close on this on what you're saying. I don't think it's in dispute. I mean, the whole foundation of the SIU is to investigate corruption. That's the long and the short. It's not in dispute at all. I think what's important that we must all do is that we also recognize that the Constitution says there is a single prosecuting authority. Part of that authority means making determinations on what should be taken to court. And I think it's important that when we have this conversation, we don't blur the lines between the two, because the prosecutors need to be accountable for the full decision, from deciding to prosecute all the way to either winning or failing to win a case, in which we then hold them accountable. So I think it's important to do that. But we'll have an opportunity to then have this discussion, this policy discussion, when we invite both ministers. I've made a note here with the Secretariat to do so. Final thing is, we will provide you with a list of things we want to know in writing that we've traversed here, which will partly be in preparation for that discussion as well. I understand we've run very long today and people have planes to catch. Please get to the airport safely. And thank you, honorable members, and we adjourn.